Okay, we are back again. So first we will sing our Indonesian anthem, Indonesia Raya. So all participants, please stand up. I invite Mr. Farhan Mahendra Syam for dua.
Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, Dean, Head and Secretary of Magister Program Study of Law, Faculty of Law, Universitas Sumatera Utara, honorable speakers and distinguished participants, that we pray together for a moment and praising God so that our activities today are blessed and can run smoothly. Allow me to lead the prayer today in a Muslim way. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين وعلى آله وأصحابه أجمعين اللهم صل على سيدنا محمد وعلى آل سيدنا محمد. Oh Allah, please bless us today to be succeed in international webinar with the theme of personal data protection in 4.0 industry. Please bless us in our every steps and deeds and make it a value of worship and knowledge that is beneficial to us. Oh Allah, please bless us with health and prosperity so that we can run this webinar smoothly without any problems. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار والحمد لله رب العالمين. السلام عليكم ورحمة الله وبركاته.
Waalaikumsalam.
I invite the Dean of Faculty of Law, Universitas Sumatera Utara, for opening speech and officially open the international webinar. Please, Dr. Mahmul Siregar, SHMO.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam, Om Swastiastu, Namo Buddhaya, salam kebajikan. Good morning, selamat pagi, salam sehat, salam sejahtera untuk kita semuanya. The Honorable Speaker and participants, Head of Magister Program Study of Law, Faculty of Law, Universitas Sumatera Utara, Professor Dr. Roka Saidin, Secretary of Magister Program Study of Law, Faculty of Law, Universitas Sumatera Utara, Dr. Mahmud Mulyadi, SIMHOM, Associate Professor Sohini Sengupta from General School of Banking and Finance, India. Good morning, nice to meet you. Thank you for your cooperation. Associate Professor Soni Zulhada from IIUM, Gambak Campus, Malaysia. Good morning, nice to meet you. Thank you for your cooperation. We hope you're always successful and healthy. Dr. Jelly Lefiza, SIMHOM, from Faculty of Law, Universitas Sumatera Utara. Dr. Joy Perdia Arifianto, SIMHOM, Faculty of Law, Universitas Sumatera Utara. Ladies and gentlemen, distinguished participants. Praise and gratitude we convey to Allah Subhanahu wa Ta'ala, God Almighty, who makes us able to be present virtually at the International Webinar on Personal Data Protection in 4.0 Industrial. The International Webinar is a regular agenda of Magister Program Study of Law, Faculty of Law, Universitas Sumatera Utara. Hopeful it will completely enlighten you pertaining to the personal data protection in 4.0 Industrial, since the aims is providing key input to the review of the protection of personal data. Ladies and gentlemen, and distinguished participants, personal data protection laws has changed markedly in the last 2 decades. Smartphone, wearable technology, and artificial intelligence have all made fast leap over the last 20 years, all driven by new ways of obtaining and processing data. Consequently, courts and regulatory authorities need to adapt, change the data protection laws to fit the 4.0 industrial revolution, as in it was not regulated yet. Moreover, legislators and policymakers are forced to design privacy and data protection laws which are flexible and thus broad by nature in order to avoid the risk of enacting policies today. As we know, it will rapidly irrelevant as technology continues to evolve with the rise of artificial intelligence and decentralized computing. Indonesia enacted a specific law concerning personal data protection, Law number 27 of 2022. Law on personal data protection mentioned that personal data include personal data of Indonesian citizens, both in and out of Indonesian territory, either being proceed in or out of Indonesia, as well as it has legal impact for Indonesia. Ladies, gentlemen, and distinguished participants, this international webinar will give a brief description, some important aspect of legal practice in countries such as Indonesia, Malaysia, India, France, and others. The honorable speakers will explore real-world application of complex legal issues in personal data protection. Ladies and gentlemen, and distinguished participants, I would like to say that I am very happy that experts in this field are attending this international webinar. I'm also delighted to welcome our participants and colleagues, even it is virtually. I believe that by participating in this webinar, we are in the right place and the right time. Together, let us accelerate the exchange of ideas and scaling up of good practices. I hope soon we will meet offline. Last but not least, I would like to officially the International Webinar on Personal Data Protection in 4.0 Industrial. I wish all of you have a very successful webinar. As the Dean of the Faculty of Law, Universitas Sumatera Utara, I would like to congratulate Magister Program Study of Law and the organizing committee in organizing international webinar. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita semuanya.
Now I invite the head of Magister Program Study of Law, Faculty of Law, Universitas Sumatera Utara, for a welcoming speech is Professor Dr. Oka Saidin, SHM.
Terima kasih. Makasih Ane. Suaranya balik. Halo. Halo, tes.
Silakan Prof, sudah oke.
Baik. Izinkan saya menyampaikan ya sebuah pantun. Ya. Pak Surono ya rasanya kalau seminar dilaksanakan di Medan kalau tak ada pantun. Ya. From Lovina Beach to Uluwatu, the beautiful one destination in Bali. Assalamualaikum warahmatullahi wabarakatuh. Best Voices is carrying out the activity. Your Excellency, Associate Professor Dr. Mahmud Siregar SHM Home, Dean at the Faculty of Law, Universitas Sumatera Utara, and all faculty head, the first, second, and the third Deputy Dean, Faculty of Law, Universitas Sumatera Utara, my appreciation for Secretary Program Magister of Law at Law Faculty University Sumatera Utara, Associate Professor Dr. Mahmud Mulyadi SHM Home. I am proud of you. All the participants in this webinar who were present virtually, Professor and the entire academic community of the Faculty of Law at Universitas Sumatera Utara. My appreciation for the speakers who have taken the time to attend this seminar, specifically to Associate Professor Dr. Sony Zulhada from International Islamic University Malaysia. Terima kasih sudah berhadir melalui virtual conference. Associate Professor Sohini Sengupta from Jindal School of Banking and Finance, India. Namaste from Sohini. Is Febabar ke Soba Badani Kelie Apakah dan Yaba. Syukriya Profesor Sohini. Dr. Joy Ferdia SHM Home from Universitas Sumatera Utara, Indonesia. Terima kasih atas kesediaannya menjadi narasumber dalam webinar ini. Associate Professor Dr. Jelly Levisa SHM Home from Universitas Sumatera Utara, Indonesia, yang telah meluangkan waktu menjadi pembicara dalam webinar ini. Currently, electronic transaction that use digital platform have a broad influence in various fields of human life on planet Earth. Almost all areas of life have been penetrated by this system. This is the fruit of the progress of science and technology, especially information technology. Transaction patterns have changed. Legal subjects who carry out transaction no longer have to come face to face by simply be present virtually. Therefore, personal data become important to protect. If not, that data can be used by other people to make transaction, break into the bank account owners, finance, and various other transaction crimes. The future era is the era of using and exploiting big data. Therefore, a number of countries in the world have issued laws in their countries to protect their citizens from misuse of personal data. The Organization for Economic and Cooperation Development, OECD, has issued a guideline governing the protection of privacy and transborder flow of personal data. For example, Malaysia. Use this guideline is applying the laws for personal data protection. Since 2010, Malaysia has had a law regarding this outline in the Personal Data Protection Act 2010. The role is to protect its citizens from misuse of personal data. What about Indonesia? Incident regarding to leakage of personal data that occurred in Indonesia in the past 2 years, which was revealed by the media. Regarding the leak of 1.3 billion data organizing from the registration of a cellular phone SIM card with a capacity of 87 gigabyte and sold on an illegal site by Bridge Forum under the name Biorka. The site has a price tag of $5,000 or 50,000 US dollar, equivalent to 744 juta rupiah. In March 2022, a cyber researcher from Singapore, namely Doug Tracer, released a list of Indonesian government sites with were included is the top 10 sites that experienced data leak. One of which was the Director General Pajak website.
Zoom lang, stock it, zoom lang.
There were 17,585 leak credentials. The situation has become a concern and prompted Indonesian government to issue Act number 27 of 2022 concerning to protection of personal data, which was ratified on October 17, October 2022. One of the important provision in the Act is that it obligates the government, in this case, the Kementerian Komunikasi dan Informatika Republik Indonesia, to carry out oversight of governance manage personal data. Of course, this is not enough. The government of Indonesia must prepare implementing regulation and the necessary instrument to support the objective of this law. Therefore, the webinar that is being held today can at least provide input to meeting Indonesian need, but both in preparing its implementing regulation and in preparing for the establishment of its management structure. Of course, the Universitas Sumatera Utara, through the Master of Law program, Magister of Law program at the Faculty of Law, Universitas Sumatera Utara, welcome this activity. Apart from realizing the achievement toward becoming a world-class university, this webinar is also intended to optimize the achievement of internationalization target according to USU's strategic plan for 20 and 25. Sebelum saya akhiri, saya ingin menyampaikan dua bait pantun. Bertolak perahu dari Belawan, hala tujuan ke Pulau Pandan. Jika ada kata-kata dan penyambutan kami yang kurang berkenan, dan mengangkat jari 10 kami mohon dimaafkan. Burung irian, burung cenderawasih, hinggap di ranting pohon cemara. Cukup sekian dan terima kasih. Mari kita ikuti acara selanjutnya. Billahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Now I would like to welcome our moderator for this session is Miss Leslie Safira. The floor goes to you, Miss. Thank you.
Thank you, Miss Hani. Ladies and gentlemen, our seminar is about to begin. Please turn on your camera. Thank you very much for preparing yourself to join our seminar. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. Respectable the Dean of Faculty of Law, Universitas Sumatera Utara, Dr. Mahmud Siregar, SHMHum. Respectable the Head of Magister of Law, Universitas Sumatera Utara, Prof. Oka Saidin, SHMHum. And the last one but not least, respectable the Secretary of Magister of Law, Universitas Sumatera Utara, Dr. Mahmud Mulyadi, SHMH. The Honorable all lecturers of Faculty of Law and Honorable all participants of this seminar. Ladies and gentlemen, I am Leslie Safira, SHMH, the moderator of today's webinar. I'm also lecturer at Faculty of Law, Universitas Sumatera Utara. I'm very pleased to see you here and welcome all of you to this event. Today's seminar is about legal protection of personal data in 4.0 industrial era. On 17 October 2022, Indonesia enacted specific law regulating personal data protection. It is law number 27 of 2022 regarding personal data protection. Like Dean said before, personal data protection law confirms its extraterritorial scope as it would also cover any personal data of Indonesia subject outside of Indonesia, either being processed in Indonesia or outside of Indonesia, provided that such processing has legal impact in Indonesia. But before we begin the presentation from the speaker, we're gonna have to take a picture first with Dean, head of Magister of Law and the Secretary of Magister of Law and all the participants. So please use your virtual background and turn on your camera. Operator, please help me to take a picture. There's 8 slides, so we're gonna take a picture one by one. In slide 1, please give your best smile. Second slide. Second slide. Third slide. The fourth. The fifth. Six. Seventh. And the last one. Okay, thank you very much, operator. So we're gonna begin our presentation. To the speaker, ladies and gentlemen, our first speaker today is Dr. Joy Ferdia Arifianto, SHMH. She's one of the lecturer of Faculty of Law, Universitas Sumatera Utara. She received her doctorate degree, but first, sorry for my pronunciation, in École Doctorale Sciences Juridiques, Politiques and Gestion in Université de Lille, France. With her dissertation title is Personal Data Protection in Financial Technology, FinTech, a proposition to Indonesia by referencing France's legal framework. So before the presentation begins, let me inform you how the presentation will be going on. After the speaker present the material of the presentation, after that, there will be a question and answer session and followed by conclusion. But if you want to ask a question, you can text on text box or you can raise your hand and say your name from institution and your country. Okay, Dr. Joy, you have 30 minutes for presentation. Please welcome, ma'am. The floor is yours.
Okay, thank you very much, Miss Les. Okay, so this is my share screen. Okay. Good morning, everyone, ladies and gentlemen. Welcome to our international webinar. First of all, I would like to present my presentation about the personal data protection by the French legal framework. So next screen, please. Next, please. First, no, too far. Okay. Questions related to protecting personal data and private data have recently been crucial. One reason why personal data protection becomes relevant lies with the widespread use of digital platforms, especially in the latest 2 years when COVID strikes, everyone forced to be online. And focus on the regulated needs regarding comprehensive protection of personal data and the lack of strategic guidance on how to govern the personal data protection in Indonesia points towards a necessity to develop a strategy for enforcing personal data protection regulation once these rules are issued. As far as we know that Undang-Undang number 27 or Law number 27 has been issued in 2020 recently. Such policy may consider the readiness of personal data controllers to perform their duties and the current public opinion on personal data protection. Next, please. The very essence of freedom and democracy is privacy. In various countries, privacy issues and regulations started to develop as a part of social society's growth. I would like to inform to you all this. France, as the European Union member state, has already established their privacy law early in 1970s. That's why this presentation will be very interesting as the comparison between France and Indonesia. Next, please. Since 2018, European Union member states have implemented the GDPR, General Data Protection Regulation. This number is constantly rising along with the necessity of the protection of citizens' data. In some democratic countries, positive law and case law concerning protecting privacy appear years before privacy was part of the international human rights regime. Next, please. The protection of the personal data of individuals in Indonesia constitutes one of the human rights within the framework of personal safety. In Article 28G of the 1945 Constitution, stipulated personal data protection. Personal data protection or the privacy of individuals has universal applications in terms of its recognition by many countries. Indonesia has regulation governing the protection of personal data in its laws. Unfortunately, before the law number 27 issued, there is no comprehensive legal framework covering personal data protection. This regulation remains sectoral with different understanding or definition of personal data. Next, please. Industry 4.0 has driven the development of the digital world in Indonesia. Digital development has also led to several new cultures and behaviors, from downloading anything to online transaction, such as shopping online, virtual reality, like this webinar, and most likely there is no boundaries at all. So in personal data protection, many parties will of course be involved. Government and private agencies are become institutions with the role of personal data managers or controllers, and also the private sector. However, this situation was not followed by public and governmental awareness about personal data protection, especially the citizens. Despite the evidence showing uncontrolled disclosure of personal data, then the personal data, like some other case in Indonesia lately, this presents many risks of various criminal acts like identity theft or couch surfing, and etc. Several challenges will arise in the implementation of the law number 27, or we call it Perlindungan Data Pribadi, Protection Data Act. Lots of citizens' personal data is collected and managed by the government for public service purposes, like in Peduli Lindungi when COVID strikes. Against this background, there are two important things to emphasize: how to maintain security and how to control the personal data protection. So about the European Union Data Protection Act, or we call it GDPR, General Data Protection Regulation, offers new ways to protect one's personal data, privacy, and other human rights. This GDPR based on some principles as follows: lawfulness, fairness, transparency, principle of purpose limitation, data minimization, data accuracy, storage limitation, data security, and accountability. This regulation gives everyone more control and require the companies, enterprises, governments, and other organizations to disclose more about their data practices to users and to regulate how they collect, process, and store people's data. Although the GDPR is an European Union regulation, this regulation will also impact the data practices of many organizations outside the EU. For example, Indonesia. This regulation applies to any organization that offers goods or services for free or for fee to people within the EU or monitors the behavior of people outside the European, regardless of where the organization is located. For example, included is in Indonesia. This includes, for example, large US, United States internet companies, advertising companies, and data brokers who process the personal data of people outside the European Union. Because in this digital era, there is no boundaries and looking for the globalization. Under the regulation or GDPR, data processing is broadly defined as any activity that affects personal data, such as collection, storage, use, or distribution of data. So in July 2020, the European Union Court issued a Schrems II decisions, which among other things invalidated the Privacy Shield framework. The case started with a lawsuit by an Austrian citizen called Mr. Maximilian Schrems, who sued Facebook and the Irish Personal Data Protection Commission to European Court. Facebook previously made transfer based on the Privacy Shield agreement, which allows companies to transfer data between servers in the world. Maximilian in his lawsuit said the standards of the data protection in United States were lower than European Union. Under the GDPR, transfer outside the European Union are possible if the destination for the transfer or the destination country meets an adequate level of protection. So it's similar, has the same standard, has established appropriate safeguard, or is based on international agreements concluded with the European Union with other country. So the Schrems case clarifies the understanding of an equivalent level of protection and the way in which the destination country can ensure this equal protection. According to the European Court, data transfer under the provisions of the GDPR requires the destination country to have a legal framework providing for effective remedies. So GDPR, it applies extraterritorially, also can apply within the European Union and outside the European Union with requirements that they have the standard and the same level of protection. Next. The court also found the mechanism in the United States do not have the same level of protection as in Europe. Thus, the court stressed the need for an independent supervisory institution that provides a dispute resolution mechanism and remedies to data subjects in the target country before the transfer of personal data to the destination country is allowed. Next, please. We have a few for French Data Protection Act nowadays. And data protection in France is principally regulated by the Act 1978 as amended. And its first article sets forth the principle that information technology is at the service of each citizen and cannot violate human identity, human rights, privacy, or individual or public liberties. So this Act 1978 is said to have inspired the drafting of Directive 1995 on personal data, which replaced by the GDPR on 2018. Next. French law regulates personal data, which is by Article number 2 of the Act 1978 as any information relating to a natural person ada suara. Can you turn off the sound, please? Ada suara. Okay, sorry. French law regulates personal data, which is by Article 2 of the Act 1978 as any information relating to a natural person who is or can be identified directly or indirectly by reference to an identification number or to one or more factors specific to him. And it applies to data controllers and data processors. Data controllers means unless expressly designated by legislative or regulatory provisions relating to this processing, a person, public authority, department, or any other organization who determines the purposes and means of the data processing. And the data processor means any person who processes personal data on behalf of the data controller is regarded as a processor. Next, please. This Commission Nationale de l'Informatique et de Liberté, or CNIL, as an independent body or institution in France, who survey the protection of data, personal data. The Act 1978 provides for procedures ensuring the confidentiality of personal information held by the government agencies and private entities. This Act 1978 also created this Independent Data Protection Authority, or CNIL, in France. In English, we say that National Data Processing and Liberties Commission. CNIL was created in 1978, beginning its main activities in 1980. The organization was formalized in response to the Safari program, an attempt by French government to create a centralized database of all French citizens. Today, it is the French administrative regulatory body responsible for enacting data privacy law. It ensures that the collection, storage, and use of French citizens' personal data is in accordance with both French law and the GDPR. And how does the CNIL relate to the European Union? Because it's a French body. The EU Charter of Fundamental Rights was the first to formalize the right of European Union citizens to personal data protection. Under the original European Union Data Protection Directive back in 1995, the data protection bodies in each member state receive a set of guidelines for drafting legislation. However, this common standard was recently replaced by the GDPR, and the GDPR is managed by the European Data Protection Board, or EDPB, which consists of representatives of the European Union member states' national data protection authorities, including the CNIL. While regulation is enacted at the European level, enforcement and guidance in France are carried out by the CNIL. Next, please. Who is subject to CNIL? Those familiar with a GDPR are aware of the fact that any entity providing its goods and services, whether paid or free, to EU citizens or tracking the online activity of European Union citizens is subject to the regulation. For example, any organization that collects, uses, or discloses data from European Union citizens is required to do so under the GDPR. This does not include websites not aimed at European Union citizens but accessible to European Union citizens, for example, a local restaurant in London. However, France also has many overseas territories which are considered an integral part of the French state. So any company falling into the following two categories is required to comply with the CNIL. Based in France or in overseas territories, and companies who collecting or processing personal data of French citizens in mainland France or in overseas territories. Okay, next. About the Indonesia Data Protection Act, law number 27 or 2020 in the year 2022. Here and after I will call the UU PDP. The GDPR protects data subjects against the misuse of personal data by companies and individuals and against the misuse of personal data by public authorities. So it applied to private sector and also the government. Interestingly, in this UU PDP, similar provisions limiting the cross-border data transfer to the GDPR are also adopted in the UU PDP. Based on the SRAM case the above mentioned. This provides a key role to secure Indonesian citizens' data to servers outside the territory of Indonesia. UU PDP is arguably a form of adaptation of European Union law to Indonesia. And next, for the conclusion, so this may finish my presentation for today, for this morning. The GDPR obliges each European Union member state to establish an independent supervisory body like CNIL in France or EDPB for the European Union. At the regional level, the European Data Protection Supervisor or European Data Protection Board is authorized to supervise the supervision of data by the institution under the European Union as supranational institution. The existence of a supervisory body is a necessity in the architecture of personal data protection in European Union. Without an independent supervisory body, the world may perceive that Indonesia's legal framework for personal data protection does not offer equal protection. Okay, so there's that. I hope I earned the privilege of your time. Merci beaucoup. Thank you. Terima kasih.
Thank you very much, Dr. Joy. Such an insightful presentation. But for the participant, if you want to ask a question, you can text on chat box, or you can directly ask to the speaker after session 2. So we're gonna begin on the second speaker. Thank you so much, Dr. Joy. Please stay with us. Good morning, Ma'am Sohini Sengupta.
Hi.
You're already here?
Yes, I'm here.
Hi, ma'am.
Hi. Can you see me properly? There is an issue with my Zoom. Am I visible?
Thank you so much. Please unmute the. We can hear your voice.
Yes, yes. Can you see me?
Can hear it.
Can you hear me?
Okay. Okay. Before the presentation, I will share the curriculum vitae of Associate Professor Sohini Sengupta. Operator, please. Okay, here's the CV of Associate Professor of Sohini Sengupta. So there's a lot of achievements. So Professor Sohini Sengupta, can I call you Dr. Sohini?
You can just call me Shohini.
No,
That's
or
fine.
just
You can call me
Associate
Shohini.
Professor. No, nggak kedengeran suaranya.
Just Shohini is good.
Okay. Okay. Sohini. I can hear.
I can hear you.
Okay, Sohini.
Hi.
Okay. She received her Magister Science in Law and Finance in Distinction in Finance 2014 till 2015 in University of Oxford. And now she is her position is Associate Professor and Associate Dean, Student Welfare, and at Jindal School of Banking and Finance, OP Jindal Global University, Institute of Eminence. So she's teaching in business laws, principle of financial regulation, banking law, technology law and policy, corporate law, for entrepreneurship. Her center affiliation director, Center for Research and Analysis in Finance, Technology and Law, non-resident fellow, Asia Center, faculty represent for the Global Hubs Salon Series, and others achievement, but it's way so much. There's a lot of achievement, right, Sohini?
That's fine.
Okay.
We can start. It doesn't matter.
Yeah. Now we can skip it to the presentation from you.
Yeah.
Okay. You want us to share your slide or?
I can share it. I can share
Okay.
my screen.
Okay, please. So I need the floor is yours.
Okay, thank you. So I hope you can see this. I'll just make this a slideshow. So
Yes,
do
I
let
can
me
see
know
it.
at any time you are unable to see it. Okay, so I have very little time. I have half an hour to go through this, but I would love it if you could join in at any point of time. I would love to have an interactive session on this because this is a topic which is fairly new and niche, and things are developing as we speak. So while the topic given to me was use of customer data, the interaction between intellectual property rights and personal rights of consumers in Indian law, I'm going to try and divide this half an hour into this lesson plan. Okay. And while I'm going to keep referring to the US and UK and certain other jurisdictions, my primary focus is going to be Indian laws. But I think a lot of countries, including Indonesia and other countries which were under colonial rule, have similar legal systems. We have similar rights and similar obligations, so you will find connections there. So let me start quickly by talking about who is a consumer. Now, who is a consumer is an evolving question of law in multiple laws. So in privacy law, technology law, we are constantly figuring out who the consumer is. And I will just give an example. But this is a question that is also concerning intellectual property rights, because now with the entry of AI systems or artificial intelligence systems, human beings are not the only construct in the argument. Because there is artwork, for example, or novels or even movies being produced by artificial intelligence, who is a consumer and who gets, therefore, consumer rights is an evolving question. But you will find these same questions in multiple other legal systems as well. For example, competition law also primarily deals with who is a consumer in a digital age. Now, when I talk about consumer, let's talk about the image that you see on the screen. I selected this image because it sort of represents the commodification of the human body. So if you look at our human body today, everything about us can be captured on data, right? So our entire body, so this includes biometrics, so iris scan, fingerprinting, facial recognition technology, things like genome testing or DNA testing, your Fitbits or your sports watches, when I open my phone using facial recognition, all of this is taking data points from the body, which means that the body, any human body, has now become a point of consumer, right? So the definition of consumer as existed in previous domains of law is no longer applicable. There is a very famous case of a company called Tala in Africa, and they are a fintech company. And one of the famous lines that the CEO raised, yes, I see a question. Please go ahead. Just unmute yourself.
Sorry, Sohini, we go to question and answer session after your presentation.
Sure. So there's a very famous case of an African company called Tala. And they use this line, which you see on the slide, which says all data is credit data. And this is really the difference between the digital age and every other, age that has come before this. Why? Because earlier, and I'm using the example of fintech here, but earlier, your banks and your financial companies would only use your credit data, how much loan you want, how much is your salary, how much is your spending, etc. But today, banks, financial institutions, governments, private individuals, educational institutions like universities are using alternative data. Now, what is alternative data? Is your social media data. Data that you put out willingly into the universe, right? So let me quickly come to, so if you see this slide, I've taken this from the Harvard Business Review. You will see three different kinds of data sets that you can see, right? You'll see self-reported data. Self-reported data is the data that I put up willingly, right? The data I shared with your university, the data I shared on Instagram today morning. The other kind of data is digital exhaust, right? Any kind of data that is, say, for example, collected by Facebook or, now Meta or Amazon, right? Any data that Google collects while we are doing, Google history, when they look for your YouTube history, when they look for the music you're listening to, that's the data that is collected from your browsing history or your location data or your metadata. And the third kind of data is your profiling data, the data that is collected by big data systems, by giant supercomputers or other kinds of use of AI. And this is the data that is used to analyze consumer behavior. Now, this is very, very important for both privacy law or personal rights of consumers and also for intellectual property rights. Now, I will just come to the similarities and differences between intellectual property and privacy law. But for the moment, these are the different kinds of data. All of these different kinds of data are collected from us, whether we know it or we don't know it. And this is collected by individuals, it's collected by state or governments, and it is also collected by private entities, right? So data in itself has become the new money. It has become a currency in many ways, right? Now, when you look at data, there are primarily two kinds of data, right? One is personal data, which is the topic of our conversation today. And personal data essentially is data that is connected very intimately with our bodies. So our biometric data, where I live, my financial data, who I'm talking to on the internet, data that can be related back to the person, back to me. And in India, unfortunately, till now, we do not have any personal data protection law. We have a judgment by the Supreme Court of India. Supreme Court is the highest court in India, much like many other countries. And in a couple of years back in 2018, the Supreme Court of India declared that the right to privacy in India is a fundamental right applicable to every person in India, not just any citizen in India, which means even if you take an Indian visa and come to India, you gain, just by entering India, you get a fundamental right to privacy. But unfortunately, we haven't moved beyond that. And there is a draft law pending in the Indian Parliament, which is our legislature. And we are waiting to see what happens with that. So that's personal data. Interestingly, the new kind of data that is roaming around in the world is non-personal data, data that is anonymized, data that cannot be linked back to a single individual. And let me give you some examples of this. Weather data, right? Your Google Maps data is all non-personal data. And this is particularly important for intellectual property rights and privacy law. Because privacy law so far under GDPR has only been concerned about personal data and not non-personal data. So for example, what happens if a community, for example, say on an island in Indonesia, there is a group of people that has been living there for many, many years, and they have their own folk songs, right? Now, under intellectual property right, because you are the creator of that folk song, you should have copyright in your act of music, correct? However, under privacy law, you cannot have group rights. Only an individual can have a right to privacy. A group cannot have a right to privacy. Similarly, for intellectual property right, so far, generally, when you talk about trademarks, patents, copyrights, design laws, pick any intellectual property right of your liking, mostly it is concerned with individual rights. However, with this new kind of non-personal data, like music data of a group of people, weather data of a city in India, which is not concerned with one person, it is concerned, say, with 100,000 people. How do you protect that kind of group data? This is a challenge that will be posed in the future to both intellectual property lawyers and also data privacy lawyers. And the simple answer today is we do not know, right? This is one complication. The other complication is that, like the environment, we don't really know much about data. So for example, 20 years ago, where I live was not such an important data set. How much I spend on coffee in a month was not very, useful data. But today, how much I spend on coffee is very, very important to Amazon, is very important to Facebook. They will sell me those kinds of advertisements on the internet. So the value of data is also changing. And this becomes another point of complication, because if you don't know the value of future data, then how do you price your intellectual property? Because remember, intellectual property rights are assets for you, either for you or for your company. But if you don't know how to price data, and you really can't price many kinds of data, my gender identity, right? Who I love, for instance, all of this is also personal data, but we don't know how to put a number on it. And therefore, because there is an economic uncertainty, we don't know how to deal with this in law. Okay, so this is about personal data, and this is about consumers. Now, let me come to the personal data protection and intellectual property regime. And anytime if I go beyond time, please do let me know, but I will try to limit myself. Now, there are intellectual property rights and privacy laws across the world generally have certain kinds of similarities. One of the primary similarities is that more or less both kinds of legal systems deal with regulation of information. So let me take again the example of, say, patents, right? The primary idea of a patent is that my information is mine, it is my patent, and I get to decide who has access to that data, who has access to that invention or copyright. I wrote a book, right? Say I wrote one book that released today. I get to decide whether I want to sell it to a publisher or I want to give it to someone else, whether I want to give it for a particular particular price or whether I want to give it for free. Privacy law is also concerned about regulation of information. It's my personal data. Do I give consent to you to take my data? Do I give consent to a bank to take my credit history and sell it? So while privacy law and IPR use different techniques or tools, the idea is we are both talking about regulation of information. The protection of personal data is also of primary importance in both IPR and privacy law. Why? Because again, the whole idea, for example, of copyright exists because I have a moral and economic right to my personal data that I create. And that kind of protection doesn't really exist in any other jurisdiction. Okay. Okay, this is a second important similarity. The third similarity is the common history between both IPR and privacy law. Across the world, both IPR and privacy law use similar kinds of legal rights and obligations. And for this, let's do a simulation. Okay, I hope you can see this. This is a question that I put up to the group. Okay. So A commission, imagine a person A tells B, pays certain money to B to take certain photographs. Now, what happens is that B is the photographer, and now B sells this, wants to sell this photograph to someone else with permission from A. Okay. But also because he's if you know photographers, they will keep a database of all the photographs that they collect, say on their personal laptop. Okay. Now C, who is say working at B's photography studio, somehow hacks into the database and steals A's photographs. The question is, what can B do to take back those photographs from C? Now, this is an interesting question, right? Because there are three parties involved. Whose data is it? Well, it's A's personal data. It's their photograph. Now, did A consent for B to take the photograph? Sure. But did B consent to give the photographs to C? No. Now, if I ask you what kind of action can B bring against C anywhere in the world, there can be multiple answers to this, right? You can use tort law, okay, which is your general suit or general case for infringement. You can sue someone in a court of law and say, you're infringing my right. This is not yours. That is in the realm of civil law. So tort law exists in a number of countries in the world. So you can use a tort law. You can also use copyright law to sue or to bring a case against C, saying that this is not your copyright. The copyright of A's photographs belongs to me and you have stolen my copyright. So this is an infringement of copyright. And if it is an infringement of copyright, both A and B can sue C. You can also remove all of this and jump right away into privacy law, right? And say, I don't want to use IPR. I want to use data protection law. In data protection law, this is a clear breach of privacy, not just of A, but also of B, right? B gets a privacy suit, gets some privacy rights or some personal rights in A's photographs. And so as you can see, these are the kinds of cases that are coming up. I can complicate this case even more. What if B was not a person? What if B was an artificial intelligence? B was an algorithm, right? Now that you know that artificial intelligence systems have gotten smarter to the point that AI is now creating art in and of itself. So what if B was not a person? B was an artist, but the artist was not a human being. The artist was an artificial intelligence system. If that is the case, then this gets even more complicated. Why? Because we don't really know what sort of rights does an AI system have. In India, for example, the copyright law or some of the cases involving AI is very unclear. There are some courts that have said that, copyright exists for human beings. AI systems cannot claim copyright. There are certain other cases in India, in certain courts have said that, you know what, AI does have a right of copyright, right? And in many other countries, there is no clarity. The Indian copyright law does not talk about this very clearly till now. So these are the kind of complications that will arise. And therefore, I would urge everyone to not look at IPR and privacy law as separate things. We are moving towards a world where you're looking at the same problem through multiple legal lens. Okay. Now let me quickly take you to the broad architecture of Indian laws. Again, this is not just particular to India. You will find this legal structure across the world, right? So in India, if you have to talk about personal data, as I said, we do not have any personal data protection law yet. There is no GDPR, there is no law. We have a draft law, which you can see on the screen on the first box. You have another draft law for non-personal data protection. But again, these are not binding laws. These are just reports. Now, the Information Technology Act of 2000 does talk about AI, does talk about data, but it's already 2000 and today we are in 2022. So many legal scholars think that in India, our law on information technology is very, very outdated. Okay. And of course, our Information Technology Act of 2000 talks about very little IPR. Now, what happens with IPR in India is that it is governed by completely different laws. As you can see, there's a Copyright Act, there's a Trademark Act, there's a Patents Act, and there are, of course, other IPR laws. There is zero interaction between the technology laws in India and the intellectual property rights in India. And this is very complicated for lawyers like us, like me, because we don't know in a given case, like the last case, which law will apply. Or can I apply multiple laws here? Can I apply the Information Technology Act and also the Copyright Act? If I apply two laws, which one prevails over the other? All of this is being decided by, unfortunately, ad hoc basis, which means different courts are deciding on different matters. Okay, so this is the broad sector. Now let me give you certain other, and I'm coming towards the very end of the, of my. So I have just two more slides after this. So in India, there is a push towards rapid digitization. So just before the pandemic, the Indian government in 2016 decided that 70% of the legal currency in India, they wanted to change it overnight to control the issue of black money. So they did something called demonetization. Now, demonetization meant that a lot of people, because they were confused about which currency to use, had to move to digital payments, right? Then, of course, for the next 2.5 years, there was the pandemic. And as you know, in the pandemic, people across the world moved on to digital. We all started transacting in credit cards, digital money, apps, using wallets, cryptocurrency even. But in India is kind of leading the world in digitization. But the problem here is that we are leading the race on digitization without a legal architecture that can take care of consumer rights in India. So in India, you have a general consumer protection law, which is very, very, very old, already over 40 years old. But we have no consumer protection law for the digital consumer, as we spoke about in the beginning of the slideshow. In the new data protection law, there is some conversation around IPR and interaction of privacy and IPR, but it's still a draft law. We are yet to see many things. However, if you see in the EU, in the European Union, if you can see on the slide, there are multiple directives, there are multiple new legal systems in place that they are trying to come up with, which is where you can see the interaction between intellectual property rights and privacy law. For example, the Computers Program Directive, which talks about interoperability, the General Copyright Law, which talks or gives people the right to do text and data mining, which is very, very important for things like open, Google Books for all of us to use, or open, knowledge systems that all of us from across the world can use. Your copyright law has to make an exception for text and data mining. Otherwise, researchers like us will not be able to use any kind of information online without paying a very, very heavy fees, right? So in EU also, there are multiple laws, but you're seeing that they're trying to merge IPR, competition, and data protection laws together so that consumer rights are protected. So the focus of the legal system is consumer protection law, right? Now, coming to the very last bit, the the one thing that I will speak about, because I'm talking to an Indonesian audience and you will relate to this, is that there is a huge regulatory problem, which means that the players in the market, right, the people who are taking data, so your big tech companies, Amazon, Google, Facebook, even Chinese companies, all of these are much, much bigger, and they have money, they have way more money than any of our governments. And this becomes a problem to take them under control. In India, for an IPR court to have jurisdiction over Facebook is very difficult, because Facebook is not just in India, Facebook is across the world. It's way more easier for these big companies with a lot of money to jump between countries because they're fully online, right? So there is a problem of enforcement of laws. And our governments, with our tight budgets, it's very difficult to keep them in control. So there's a huge regulatory challenge coming up in the future. There is a huge informational challenge, by which I mean that the people you are trying to regulate, which means these companies, are far bigger than the government. So, and they have more information about consumers. So an Amazon today has more information about me than my government. And so there is a huge information asymmetry or gap between private companies and governments. The third thing is that we need to move away, as I said, from this binary approach of, oh, this is the intellectual, this is a copyright problem, and this is a data protection problem. And I believe, and this is, feel free to jump in here, I believe that we need to move beyond consent. We need to talk about fundamental rights, and we need to talk about consumer protection in general, no matter which law you jump to. And lastly, we are moving to an age where there is very little difference between public information and private information. And let me give you one last example of this, which is, for example, I put up something on social media and my profile is on private, which means only my friends and family can see it. However, even if I do so, Instagram still has control over my data, right? So this difference between, oh, it's my data, it's protected under copyright law, it's protected under trademark law and under privacy law, may not really be true when you come to real life, because multiple third parties like banks, advertisers, companies, etc., may have access to data. So we need to move beyond what is public and private and go back to consumer protection. I think I'll stop here because I think I've run out of time. But I'll stop here, and I'm very happy to discuss more about, and very happy to hear what you guys think as well.
Thank you very much, Sohini. Such an informative and interesting presentation from you. So in India, still have a regulation about personal data protection, right? Like just like in Indonesia, we just have it on 2022. So we're gonna jump into answer and question session. There's some participant who wants to ask the speaker directly about the personal data protection. So I've seen before who wants to raise hands. You can ask to Dr. Joy or to Sohini directly, please. Okay, here's Husin Saidi Sasa. Can you turn on the cameras, sir? Okay.
Wait.
Please unmute. Still, I can hear your voice.
Okay, well, I will ask to Ms. Sohini, to Professor Sohini Singupta. My name is Husin Saidi Sasa. I'm from Universitas Sumatera Utara. I will ask to Miss. The first one is, why does India not have a data protection bill yet? The second one is data protection law is important? Thank you.
Thank you, Hussein. I don't know if I know the answer to the first one. Why do we not have data protection law? Because I think for the last, once GDPR came in 2016, 2017, it was implemented finally in 2018. India and a lot of other countries woke up and said, okay, we also need a law. And since that time, there has been an effort to draft the law. But in every case, there were 2 other draft laws before this. There were massive protests in India because the draft laws that the Indian government came up with was simply not strong enough. And there were a lot of exceptions that were drafted into the law, which means the Indian government said, yes, we will protect everyone's data, but the government has all access to data even without consent. So this led to massive protests in India. And therefore, after the next 2 years, every time the government goes back and comes back with the draft bill. Unfortunately, we are still stuck there. That's the short answer to the first question. And the second question, is data protection law important? Well, absolutely. We are living in a world where we saw the controversy around Trump's election. We are living in a world with fake news, lots of other, data, and data is the new currency. So we definitely need to have a system in place to protect that. However, as I said, I think we need to move beyond the idea that, okay, we need to protect data only through data protection law. Data protection law is important, but so are many other kinds of laws, and all of them need to work simultaneously together so that citizens like you and me are protected fully. So I'll stop there.
Okay, thank you, Sohini. Hussein, is it clear? See? So Sohini said, of course, it's important about the personal data protection regulation to regulate from government, because there's a lot of data abuse in industrial era in 4.0, like everyone use your data to do something in credit card, like use your credit card without permission, right? So is it clear? So I think it's clear. So we're gonna jump to next question. So it's from chat box. Okay, please still raise your hand if you still want to ask. This one is for Sohini again. So Sohini, how the India government concerned to anticipate and protect the personal data leak? Do you think the India's regulation and laws are strong enough to be applied to protect someone's personal data? In India, as we know, India ID grow fast, but not followed by supporting laws and regulation. Please,
no,
Sohini.
the simple answer is no. The Indian data protection regulation, the current laws are not strong enough. And that has been the point of demand for many, many years now. Now, how does the Indian government anticipate and protect personal data leak? Well, actually, very disturbingly, we had this case of Pegasus. Pegasus is a virus that got leaked in India, and many high-profile people in the government, both in the ruling party and the opposition, they got affected. And the Pegasus leak affected many countries. And there has been no conclusion. We do not know where this virus came from, and the data of the government officials were leaked. So it is very disturbing. It is very scary. How we protect it today is 2 mechanisms. One is the Information Technology Act. As I said, it's a very old law, but that's all we have. The other is the Supreme Court judgment, which says the right to privacy is the fundamental right. But barring that, that's about it. We don't really have many other laws. But hopefully in the future, we are going to have a new law that can help protect the rights.
Thank you, Sohini. It happens in Indonesia too. The government data leak. If you ever heard hacker, it happens in Indonesia too. But it's before the PDP regulations. Before we have the PDP regulation. Okay. To the next question from Miss Stella. Do you want to ask to who?
Okay, thank you.
please.
It can hear. Okay. I want to ask for Ms. Sohini that how is the concept of the liability in information technology in India? Because we have shown in Indonesia, we have the Act, the Information and Technology Act, and that is can be shown like the concept of economic, that is green marketing, have shown. So in India, what concept of liability, that is the presumed liability or the strict liability or absolute liability, which is shown in India? Because if something have wrong, someone will cases to us like that. Okay, I want to ask what liability, that's the important ones. Thank you.
That's a great question. That's a great question. So I think it depends on, as I said, it depends on what the consumer is claiming. So if you want to stop someone from stealing your data, you can file a general civil suit, a general civil law, which says stop, which is the case of infringement, right? You file a case of infringement saying you stop doing what you're doing. It's a cease and desist notice. That's one. The second is under the information technology law in India. There's an entire chapter on cyber crimes. So if a cyber crime happens, like bullying online, harassment online, cheating, fraud, bank fraud, for example, you can go under the Information Technology Act. And it is a general liability. There is no strict liability that is applied. The third is constitutional right. So the right to privacy now is a part of our fundamental right to life because of the Supreme Court judgment. So you can also file a constitutional breach of your fundamental right, saying my fundamental right to privacy has been breached, in which case the court will give you a constitutional remedy. But economic remedy, there is very little. There can be a general compensation, but that's about it. There is no strict liability. As I said, we are still waiting for the new data protection law to see what kind of liability will be imposed. But our draft law right now is looking a lot like GDPR. So whatever is there in GDPR, something similar in India will come up.
Okay, thank you, Sohini. Okay, wait a moment. Okay, wait a moment. I will give you a chance to ask a question.
A question, please.
So I'm curious to in Indonesia to Dr. Joy, how's in Indonesia about after we have a regulation about the personal data protection in 2022, because you already know and learn about the personal data protection in France, right? So how is it now in Indonesia after we have the regulation?
Thank you, Ms. Leslie. About in Indonesia itself, as we know now, because it is currently new, it's still new, so it is along the way. And in my opinion, it's like the law number 27 in Indonesia is like adapting from GDPR, which has a high standard for the protection law, because especially in France, the Data Protection Act is already enacted in 1970s. So it is still the only way to follow the rules, and we still, like wait and see because the regulation is still new. And if I may say, for the first thing first is to create awareness. Firstly, especially from the citizen itself, because in Indonesia, for the media social, especially millennials, they are willingly to like to share their personal data. So first thing first is, I think, to create awareness first from the citizen itself. Thank you.
Okay, thank you. Because the millennials right now is really they use their face to use application like AI. It can use by another application to abuse your data, right? Is it right, like what you said, Dr. Joy, we have to give their awareness to about their personal data. So, so there's another question from about this Indonesian regulation in personal data protection. We will discuss it again with Dr. Jelly Leviza in part 2 in fourth session. It's about like after we break, we're gonna discuss it again. But now we gonna have another question from Pak Dedi Kusnadi.
Okay.
Okay, please, Pak Dedi.
Thank you, Ms. Leslie Savera. I need to send a question to Ms. Sohini. Okay, number one, Ms. Sohini, how I can classify that a data, my data I mean, is public or private? Because I can see this is there a fuzzy area in this situation to classify which one is public or which one is private. Okay, the number two, how we can classify that publishing our data is a violence against us. Is that economic profits for someone maybe or something else? From this case, I mean, I do nothing. I'm not less or less something, but there is someone take some advantage from my data. Is that a crime? Okay, thank you, Ms. Sohini.
Thank you for that question. These are two really interesting. I mean, you've touched on the heart of some of the challenges for the future. So one is, what is public data versus private data? Now, if you see GDPR and most other legal systems that have gained inspiration from GDPR, including India, we try and protect all kinds of personal data, all kinds, whether it's public or private. To some extent, it is protected. However, GDPR uses the tool of consent. In most cases, there are exceptions to this, but in most cases, it uses consent. Do you consent to anyone? And this links to your second question as well. Do you consent to someone taking your data, whether for economic reasons or for any other reason? I'll give you an example of this. All of us, if we sign up to Instagram or any other social media or WhatsApp, are willingly, under the consent, the terms and conditions, all of us have willingly given the right to Facebook or Meta to use our pictures and to use our data. We have all consented to that. Even Zoom, we've all consented to giving our personal data to Zoom to a limited extent. So in most legal systems, what the law has done is they've given the burden to the consumer to decide whether you want to consent to someone taking your data, public or private. Copyright law or patent law, for instance, coming to IPR, is a personal right. It is my right over an invention. It is my right over a music or a book. But I get to decide, even though it's private information, whether you get to have my right or not. So I think the more important question is not whether it's public data and private data, because the moment you start distinguishing, you will see there is stronger protection for private data and less protection for public data. Just because I have decided to give my data on Facebook and make it public should not mean that I've consented to a bank fraud or anyone across the world taking my data. So this is in my opinion, I think these binaries between public and private only dilute consumer rights. We should talk about rights in its entirety. That's one. And very quickly, to sum up my points for the second question you asked, is it wrong to take someone's data for non-economic reasons? Well, under GDPR and under Indian laws as well, as long as you have consent, you can do certain things. However, even without consent, a lot of data is taken. For example, profiling on the internet. done by for surveillance reasons, right? For economic surveillance by regulators, by tax authorities, by international firms, even by governments. So again, GDPR doesn't really make a distinction between taking someone's data for economic purposes and other purposes. If you're taking someone's data, the same kind of liabilities and the same kind of rights apply to you. So even if you take someone's data and just keep it with yourself without that person's consent, it may still be considered an offense under GDPR. I hope I was clear on that, but if you have any follow-up questions, I'm happy to take that.
Even Ms. Sohini, even I do not lose anything, I do nothing, but there is someone take advantage from my data. I mean, is that a crime?
Yes, it is an offense if they have done it.
Oh, that's offense.
There are some exceptions to it. Governments get some. So, for example, during the pandemic, governments in many of our countries were taking our health data and our location data, and that is deemed legal under that country's laws. So, for instance, under India's disaster management law, the Indian government could take your health data during a pandemic without your consent. So that was legal, but generally, no, it's an offense. It is a crime.
Yes, thank you, Ms. Sohini. Thank you.
Welcome.
Okay, thank you so much for the question, Pak Dedi Kusnadi. Maybe I'm curious too. In Paris, as we know, there's if we take a picture of evil tower in the night, Dr. Joy, it's for economics purpose is not it's not allowed to take a picture in front of an evil tower in the night for economics purposes, right? But how in Indonesia, if we take a picture in front of personal property of someone, like in front of someone's house, and then we post it on Instagram for like for inspiring someone, but we post it for our economics purpose. Sorry, how is it?
So if in France, especially like you said in Paris, we cannot take a picture for Eiffel Tower in, I think, from some other side. So it's not the whole Eiffel Tower. You cannot picture it, but somehow in some point of view, because it's, you know, it's because of it's beautiful and it's very magnificent. But in Indonesia, well, it's especially like Sanini said, that about the how to create the awareness first, and to posting about another photo or picture from other people. If you not consent, if it's not based by consent, so you cannot do it, you know. But in GDPR, in European Union, there is another regulation in 2019, I guess. I forget the exact time, but along with the GDPR, which stipulated about the personal data, there is also a regulation who regulate about the non-personal data. So it's not all about the personal data, all about yourself, all about the boundaries and everything, but there is also an exceptional for the non-personal data, which you can use it by no need to resign to sign the consent or to give the approval or anything. But in every transaction which monetize or you can give you money, so that's the GDPR will apply. Is it
Okay.
enough, Miss
Okay.
Leslie?
Thank you so much, Dr. Joy. Okay, we jump to another question. It's from TM Afriandi Adrian. Please, the floor is yours.
Hello, can you hear me?
Yes, please.
Okay, thank you, Miss Leslie. I have a question for Mrs. Sohini. Basically, what I'm trying to ask about to Miss Sohini is what happened if the leaking of the personal data is come from a state-owned company, like a government company? Is there anything in India that regulates about it? I just want to ask the question about it. So, thank you.
You've asked the most controversial question.
Yeah, no, I know.
So yes, there is in part. So the court decision that gave all people in India the fundamental right to privacy also says that governments in national security or in terrorism cases or in exceptional cases like the pandemic will get to take people's data without consent. And this exception also exists in GDPR. There is a government exceptional case. And you will see this in data protection laws across the world. Governments and states do have some rights over your data, even without your consent, in specific times. So that exists in India as well. But of course, in India, we don't have a data protection law. So state, right now, we only have one judgment. So yeah, they can take data.
Okay, I see. Thank you.
Okay, thank you.
One question, please.
Okay, wait a moment, but ready?
Okay.
Give a chance to another participant. Miss Anggi Maisara, please.
Well, thank you for giving me the opportunity, Ms. Leslie. I would like to give a questions to Mrs. Joy and also both for Mrs. Sohini as well. This is actually my personal experiences related with the national banking in Indonesia. They contact me for some issues that related with the other clients of this particular banking. So what happened was that this bank contacted me to ask about one clients that related with me in terms of relatives or family or in a working area. And I just wonder, how do they know about my number? Because that number is actually specifically for my financial needs. There is no a possibility for any kind of bank people who know this number, because I just use this number for financial needs. The thing is, they say that first, they are not from the banks, but they are the third party that hired by the banks. So to do the investigations about who people linked to their clients. What I'm trying to ask is, do they have the banks, do the banks have the visibility, or are they allowed to do corporations or hire the third party to do the investigations? Because I believe when they hire the third party to do the investigations, they should probably give the personal data of their intended clients. Thank you.
You wanna answer the question first, maybe? Dr. Joy, do you wanna be the first who answer?
Okay, I will answer your question, Miss Anggi. So about the third party and everything, you like it or not in this, in our world, in Indonesia, especially in Asia, it's not only the bank that, control the data. They also have the third party to, for the mobile banking, for internet banking, and also for anything online. However, if I may comment to your problems, is the first thing first is to contact the bank. So you need to speak up about your inconvenience, and then you ask them to help you. Because now, if there is anything problems with the personal data, including in banking transaction, if the bank is not respond to your for your protest or respond or anything, you can also comment and also speak up to the OJK, the financial institution.
To add with that, Ms. Joy, I've already
Yes.
confirmed to the bank and asked
Mhm.
whether how do they know about my numbers and so on, and they confirm that they work with the third party to do the
Mhm.
investigation. That's so
Okay. Yeah, that's why you have to, for this third party, it's also they have this, like some kind of agreements, but somehow as the clients from the banks, you have the rights to, to speak up about your inconvenience. That's all that we can do at this time, because the regulation is still new. So along the way, so like for example, right now we really do not have any choices to to make a selfie with our identity card, for the cryptocurrency, for the peer-to-peer lending and everything. So what you can do is to protect yourself first, I think so, because in Indonesia, and especially maybe, I don't know if in India also like that, this problematics is you have to face the corporate first before you meet the government. In Europe, it's very different, when you can first meet the government, and then after that, the government will handle the situation with the client and the corporation. Is it quite answers your question, Miss Anggi? Okay, maybe Sonini would like to comment.
It's the same case in India. It's absolutely the same case in India. There is no regulator right now, so you go to your bank, raise your complaint, hope that the financial consumer protection laws will help you, but really that's difficult. And along with this, because it's financial data, please remember that this third party data sharing happens with not just other companies, they will also happen with your government and other governments as part of anti-money laundering regulations that almost all countries in the world, definitely including Indonesia and India, we have adopted the World Bank and the IMF's anti-money laundering regulations, which is why all of our know your customer details, when you set up any kind of financial transaction with your bank, you have to give your name, address, identity card, other kind of details, including biometric details. All of this is required under international regulations as well. So when you're talking about third party data sharing, this happens both at national levels and also with international regulators. So right now we are in a very dicey situation. I hope your issue is resolved, but same case in India.
Okay, thank you, Sohini and Dr. Joy. So if I can share my, I've worked in bank before as a lecturer. So bank is allowed to change information in which who is affiliate, like insurance, like so. Before you have make a account bank, right? You can check if you allowed or you're not allowed to connect with others third part or no, like that. So if you're not allowed, the third party like insurance, it will not contact you, like that. So like Dr. Joy said before, it's about if you feel inconvenient with that, you can complain to your bank. So don't give my data to others, even if your affiliate corporate, like that. Okay. Okay, thank you. We have another question. Pak Dedi, please. I'm so sorry. We give chance to another participant first, because you already have give question.
Just one
So,
question, Ms. Leslie.
yes, I will give you chance, but maybe for Husin first.
Okay, thank you.
Okay.
Okay, thank you, Miss. I'm sorry I have connection issue. Before I asked earlier about why does India not have a data protection yet, a data protection bill yet. Okay, to continue my question, I would like to ask to Miss how the evaluation of data protection law in India. Thank you.
Yes, so as I was saying earlier, the draft laws, this is the third draft law. In the earlier versions of the draft law, citizens did not like the law. So there were a lot of protests. A lot of letters were written to the government, and a lot of us petitioned to the government because the data protection laws had a lot of exceptions. As I said, the draft laws had provisions in them which said that the government gets your data without consent. So a lot of people protested against this because a lot of data in India today is being taken by the Indian government. And so therefore, the data protection law is still being debated in Parliament. But I think we are going to get a new data protection law very soon in 2023. So very soon we are going to get it.
What is considered? Why still debated? Why? What is problem?
The problem with the law, the draft law?
Okay, thank you, Miss.
Okay. Okay, turn to Pak Dedi Kusnadi, please.
Okay, thank you, Miss Leslie. One question to Miss Joy and Miss Sohini, maybe. Okay. There is a dualism in this case. I can see there is due to 4.0 revolution industrial, there is a principle, transparency, information transparency principle. Against transparency is sharing, sharing information. And another side, there is a protection data. Protection, is limitation. How you can explain to me, please, to explain this dualism, protection data and information transparency. Thank you.
Okay, so Mr. Dedi, thank you for your question. It is a dualism between to protect the data, and then you have to, you have no other option to share your data, especially when you ask by the government. For example, like in Peduli Lindungi, there is a big data there. You don't have any choices. You don't have any option to unless to obey the requirements, you know. But if you read the terms like the consent, if you read the terms and everything, but somehow, you know, me myself also, I don't read the terms and the privacy agreement because it's very, you know, very lot of numbers to read, and I don't have any time because I need to do anything in my life. But once you click yes, then you can share, and you cannot, you know, you cannot comment, or you cannot respond, or you cannot complain about this data. But however, in this privacy agreement, as regulated in the GDPR, or maybe in India, or maybe in Indonesia also, you like it or not, as soon as you agree to the consent, then you have to follow the rules. But somehow in that privacy agreement, it's also the I mean the clause, it's already, you know, like protect the data. But in this digital revolution 4.0, you have to, you know, like aware about yourself first. I think it's important for things now. So Ms. Sonini, do you have any comments?
No, I completely agree with what you said. So
Okay.
I think when the transparency principle that you mentioned, I think the original objective was that the consumer, or whoever's rights your data you're taking, should know what the data is being taken for how much time, and for what purpose, right? So under GDPR, you have the whole list of principles under Article 6 and 7, which says that, hey, this is why, these are the categories of data I am taking your data for. I'm only going to use it for XYZ reasons, which is purpose limitation. So if I tell you that I'm taking your data for the webinar, I can't use this data now for, sending it to anyone else. So I am limited by the purpose that I am setting it for. There's another principle of data minimization, which means collect only data that is important. Don't collect excess data, right? Deletion of data after the purpose is done. All of this is part of the transparency principle. But as, Ms. Joy was saying, the problem is that what companies do is they will write it at very, very small fine print in a 50-page terms and licenses, right? So just before I joined the Zoom meeting, Zoom required me to update my privacy policy. I didn't have time. I had 30 seconds to join. I just clicked, I agree. So which is why now the new laws, data protection laws, are also putting an additional burden on companies, which is that your terms and conditions have to be small. They have to be in a language that the regular consumer, not lawyers, not experts, regular consumers can understand and can consent to. And this is why in most data protection laws, we make a distinction between consent and informed consent. What I did before joining Zoom is consent. I consented. But is it informed? Do I have knowledge of what I consented to? Well, no. So that's not informed consent. And now companies are being pushed to give meaningful consent choices to consumers. My choice as a consumer can't be, yes, I agree, and no, I don't agree. That's not really a choice, So companies are being pushed to that, but we'll see where this goes.
Thank you, Ms. Joy, and thank you, Ms. Sohini.
Okay, it's all clear, Pak Dedi Kusnadi.
Sementara clear, Ms. Hasdi.
Okay, thank you.
Thank you.
Thank you very much. So there's no more question for this presentation to speaker. So I want to have a closing statement from speaker, from Dr. Joy and from Sohini. Please, Dr. Joy first. can you give us a closing statement?
Well, firstly, I would like to thank you for this opportunity, Ms. Leslie, especially to Mr. Mahmud Mulyadi and Professor Oka Saidin for this opportunity to give the information and sharing my, my knowledge or experiences from where I learned about this protection data. And if I may comment and anything, it's, well, it's not already finished, and you say that you are ready to face the globality and the revolution, the internet revolution. But for the first thing first is like I want you to create your awareness first from yourself. So you have to start from yourself first, and everything in this technology evolution or disruption, all the regulation is based on the consent, the privacy shield agreement, and then sometimes, like Ms. Sonini said, you have no choice unless you only choose or click yes. That's why this data protection, and somehow any citizens not doesn't really understand what's the meaning of the personal data itself. Somehow for the maybe for the younger person here, the first thing first that you can do is like, like for your Instagram profile or for your WhatsApp profile, you can hide your profile, what you want to give to anyone to see in general, only maybe your profile picture or maybe your online status or anything. I think from me it's only that. And for Ms. Sonini, please.
Thank you so much for that. Thank you, Leslie, for inviting me to this. This has been such a educational experience for me, because I didn't know anything about Indonesian law, but just in this one and a half hours, I've learned so much about the Indonesian law. And I think I now believe that there are more similarities than I knew of. So I would also like to, echo Ms. Joy's sentiments. That one, we need to, especially people in Asia, in global South, we have very different histories. We have a different culture from the Western democracies. So number one is that we don't need to look at GDPR as the only blueprint. We can adapt from GDPR, but we need to adjust for our own climates, right? So for example, because of our histories of colonial past, both Indonesia and India have been under colonial rulers. A lot of our legal systems are adopted from our colonial rulers. So to give an example, in India, the Information Technology Act and many of the internet laws in India are directly from the British laws. We have not changed them, right? The purpose of those laws are no longer the same, but we are left with, the skeletons of the past. So therefore, we need to look at what our governments, what data is being taken from us now. The way these big tech companies take data from us is very different, because remember that Asia is the emerging market. This is where all companies are coming now to take data. So I would say our consumer protection, and as Ms. Joy very rightly pointed out, consumer awareness in these countries is much, much lower. Our citizens today don't understand the language. Many of them do not still have internet connection. So we need to account for that. And therefore, I believe our consumer protection rights here needs to be much stronger than what happens in Europe, for instance. Our, our governments, our courts are not as fast. We don't have that many resources. We need to think about all of this. So as people, all of us that are here that are trying to understand, I would say that this law is evolving as we speak. So we need to keep up with things, and not to get caught up too much in what is happening in GDPR. Take inspiration, but then look at what our countries did and then adapt to that. But thank you so much for inviting me here. I have one full page of notes written. That's how much I learned from the session. It was a fantastic experience, and I hope I see you on this side as well in India.
Thank you so much, Dr. Joy and Sohini. Such an informative and interesting presentation, and all your information to us, to all participants, and especially for me too. Just so like Dr. Joy said, like we need to escalate our awareness about the personal data protection, because even we knew in personal data protection regulation in Indonesia, but we have more awareness about that. Even in India, still outdated about the personal data regulation, but their law about personal and non-personal data are like GDPR law in India. So I have one quote for close this session. Like it's from Socrates. True knowledge exists is knowing that you know nothing. So that's why we have a webinar about PDP today. So we have learned a lot about it. But this session is still not yet finished. So all the participants, we're gonna have a break session for a while. We're gonna back at 1:20 p.m. for the next session with a speaker, Associated Prof. Sony Zulhuda from Malaysia and Dr. Jelly Leviza from Indonesia. So thank you so much. Finally, give the applause for the speaker and for you all. Thank you. I give it back to the webinar to MC. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you very much, our moderator, Ms. Leslie Safira SHMH. So now we are back to give the certificate to a speaker. So I'd like to call our secretary program, the Magister Program Study of Law, Faculty of Law, Universitas Sumatera Utara, Dr. Mahmud Mulyadi, SHM. So please, sir.
Okay.
Dr. Mahmud Mulyadi will give the certificate to Dr. Joy Ferdia Arifianto, SHMH, as a speaker, International Webinar on Personal Data Protection 4.0 Industrial.
Okay, Dr. Joy, thank you so much for your participation today, and a great topic. And inshallah, to the next we can increase our topic again about the a crucial topic. And inshallah, the next time we can invite Sohini to come to Medan. Thank you so much, and we give applause to Dr. Joy.
Thank you so much.
Okay, next, we're gonna give the certificate to Associate Professor Sohini Sengupta as a speaker on International Webinar on Personal Data Protection in 4.0 Industrial. So please, Dr. Mahmud, give the certificate to Associate Professor Sohini.
Sohini, thanks so much for your participation today, and you have give us more information and we can increase our knowledge. So next time, may God give us time to Sohini come to Universitas Sumatera Utara to Medan. Thanks so much, and God bless God bless you, and then God bless we all. Thank you so much. We give applause to Sohini.
Thank you. It was my privilege. Thank you so much.
Thank you so much to the all participant and to the all speaker that has attended this international webinar today. So I would like to give you an attendance link on this webinar, and you must fill the attendance Google form on chat. You can check in our chat in Zoom meeting. After that, we're gonna continue this webinar like 1 p.m. So Dr. Jelly and Dr. Sony will provide us to this webinar, and then it will be moderated by Miss Siti Khairunisa SHMH, and then I will be the MC again. So please enter the attendance link on Zoom room meeting on this chat. So I would like, maybe we can take a picture again for documentation. Okay, there's no need to picture. Okay, see. So thank you very much, and we're gonna take a break. See you at 1 p.m. Assalamualaikum warahmatullahi wabarakatuh. Me and all participants really say thanks so much to Prof. Sohini Senggapta. It's really an honor to meet you in this Zoom meeting. Thank you very much. Check.
Tes.
Sadly dimatikan ya speaker.
Testing.
Ya, sudah aja mana saya duluan deh.
Oh. Tes. Good afternoon, everyone, dear participants. Mr. Associate Prof. Sony, is there available in our Zoom? Associate Professor Sony Zulhuda. Sir Sony, can get you? I'll try to recall Mr. Associate Prof. Sony Zulhuda in our Zoom. Sir Sony Zulhuda.
To the all participants, please use the virtual background we have shared on chat on Zoom meeting. So please use your virtual background. Speaker will attend this Zoom meeting around 5 minutes more. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon to all the participants and to all speakers that have attended this event today. Assalamualaikum to Dr. Jelly Lefiza, SIM Pool. Back again with me, Hanifa Aziza, as MC for today. Now we continue our international webinar personal data protection in 4.0 industrial. And we'll lead by our moderator, Ms. Siti Khairunisa SHM. And I will also like to tell again to all participants, please use virtual background who has shared on our chat box. So, Ms. Khairunisa Ginte, the stage is yours, please.
Thank you, Hanifa Aziza, for hosting this webinar today. Good afternoon, everyone, depending who you are. Honorable our Dean of Law Faculty, Dr. Mahfuz Regar SIMH, the Honorable the Secretary of Study Program, Magister of Law, University of North Sumatra, Dr. Mahmud Mulyadi SIMH, the Honorable all lecturers and Honorable distinguished speaker and the participants. First of all, I would like to welcome to our speaker for today. Thank you for squeezing the time to join us today. Welcome, International Webinar on Personal Data Protection in 4.0 Industrial. My name is Siti Khairunisa. I'll be moderating for International Webinar. Before our session begin, we have to take a picture for a while. I should allow to the participant to open your camera because we have to take a picture for a while. Yeah, maybe we have to take a minute. Okay, good afternoon, Prof. Associate Prof. Sony Zulhuda.
Yes, good afternoon.
Okay, before
Sorry, I
we
joined a bit
before we
late.
start, we have to take a photo.
Sure.
Shall we have a virtual background from our webinar, sir?
Yes, sure. I'm setting it up.
Okay, thank you, sir. Okay, to all the participants, please use our virtual background. We have to take for a while to take a photo. Please turn on your camera and use the virtual background. Yeah, maybe 1 minute to go to take the photo. Okay, to all the participants, please turn on your camera. Please use the virtual background has been attached in our chat room. Okay, to all the participants, please mute the sounds. We have to begin because we're about to begin. Okay, and now we have to take a picture. 1, 2, 3 on the slide one. Okay, smile. Okay, and the second slide is 1, 2, 3. Okay, and the third slide, 1, 2, 3. All right. Okay, and the last slide. Oh. Okay, wait a minute. 1, 2, 3, and the last slide. 1, 2, 3. Okay, it's all enough. We will again back. Okay, we will back to the sessions. Before the take our session begin, I would like to introduce our panel members. First speaker, our associate Prof. Sony Zulhuda, and the last speaker is Dr. Jelly Lefiza SIMH. As we know, data privacy has been a significant topic of discussion during the past few years. Now, many people realize that companies may collect their data without telling them, and companies make money by taking this data and selling to the other people. Recently, Indonesia passed a new law concerning personal data protection, and so Malaysia do this. And the main responsibility of PDP or personal data protection is to enforce and regulate PDPA in Malaysia. And the fee focus on processing of personal data in commercial transaction in avoiding misuse of personal data. So here is we invite Mr. Sony Zulhuda for presentation. Let's take a moment to introduce our speaker, Associate Prof. Sony Zulhuda. Okay, his main interest is the intersection of law and technology, especially that concern information law, internet government, information security, and data protection. He earned PhD Law International Islamic University Malaysia IIUM 2010, and wrote a doctoral thesis on legal form of information security in Malaysia. His recent advisory work included study of cybersecurity legislation in Malaysia and a review of Malaysia personal data protection. It's very easy to find his paper both national and international scope. So today we have to listen to this talk on the protection of personal data in Malaysia. Associate Professor Junior Juhoda, the floor is yours.
Okay, I'd like to use my own slide. So now I'm sharing my screen. Is my screen now can be seen?
Okay, we have to try to allow to share. Okay, it works, sir.
Okay, can you see now my screen? Is it on?
Yes, I see that.
Okay. Thank you. And my voice, is it okay? Just to check.
Clearly. Okay.
Clearly. Alhamdulillah. Thank you so much, Miss Siti Khairunisa. Thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you for the invitation. I'd like to thank Universitas Sumatra Utara Faculty of Law and the organizer of this webinar, all who are involved in this webinar. I'd like to congratulate. Yeah, it is a very, I think, very important and timely. Yeah, it is very important and it is timely to discuss about this topic. As it has been mentioned, I think starting from this morning, we have seen how this topic has emerged very crucial for many reasons. Yeah, even though in my part, I have been speaking about this topic since 20 years ago, actually, since we had started in Malaysia, and then in 2010, Malaysia had the law. So we kept on discussing and sharing about this. The good thing for Malaysia is to have, for Indonesia to have joined the more than 100 countries now who already have the comprehensive law on personal data protection. So I'd like to congratulate Indonesia and the government of Indonesia for taking this a very important step, even though people said this is because of the G20 summit, but it doesn't matter for one reason or another. Yeah, as long as we have this area being finally regulated, because it is timely. As we know that we already, everyone has your gadgets, digital tools with us, and our lifestyle had also improved digitally. So in every moment, data is very important element in our life, both in our personal and professional lives. Therefore, when it comes to dealing with data, then comes the issue, to what extent this data is being regulated. Is it your data? Is it my data? What about the personal data taken from the public domains? Is it anyone's data for that purpose? Do I have to get someone's consent in order to use this data? And if I were to use this data, how much I can use it? And can I sell it to other people, and so on and so forth? So lots of questions now have been emerged, especially after we have these questions. And the good thing, of course, Indonesia with the law number 27 year 2022, we have to move forward, and we have to move very, very fast. And we can learn from our neighbor countries. Indonesia has been preceded by other countries when it comes to data protection legislation. Of course, first with Malaysia in 2010, and then Singapore in 2012, and then Philippines in the 2012 as well, and Thailand in 2019. So these countries have had their law already in place, and they enforced it. So it is for us to learn from these countries, yeah, what have been done, what are the challenges. Yeah, of course, it is not all well in Malaysia. Even though we already have the law since 2010, does not mean that all the law is well implemented, yeah, because there are also some problems, yeah, when it comes to the enforcement. So let me start with this slide with the little background. What you see here is that Malaysia, perhaps you all have known that we just had a new ministry, a new government. Yeah, new government has been recently formed, and the good thing about this government, I believe, is that they are very aware of the issues of data breaches, of issues regarding cyber crimes and so on. Because Malaysia as a country is not a quiet place. Malaysia has not been quiet when it comes to cyber crime. There had been so many incidents, so many problems. Yeah, even though we already have the law. Yeah, so you don't think that since you already have the law, then all problem will disappear. No, it is not the case. Yeah, a good law is as good as its enforcement. So how good we enforce the law, only then we will see the result. Yeah, if the law is only there written on paper, so there's no result at all. So as you see in this, these are some of the headlines that I recently collected, and it's very recent. In Malaysia, for example, Personal Data Protection Department, yeah, discloses there are 3,699 reports on breaches since 2017. So it's like 5 years. This is 5 years in statistic. The commonest through online purchases. Our online purchases now, I believe we all are involved in online purchases. Either you become buyers or become purchaser. Yeah, we already choose this online platform in order to transact and make business. So you must remember that when it comes to online transactions, people trade data. Yeah, people exchange data. So when it comes to exchanging data, so data will be revealed, will be used, or may be misused. Therefore, some people may misuse other people's data in order for transaction. For example, instead of giving my own data, I use other people's data. So that also can happen. For what reason? Different numbers of reasons. Sometimes you just don't want to reveal yourself, or I don't want people to know that I just bought, for example, certain types of drugs and whatnot. So what you want to do is you want to hide your identity by using other people's data. Therefore, other people's data will be the one that appear in the transaction rather than your own data. So that is one of the reason. The other reason, of course, when it comes to the misuse of credit card numbers, credit card details. You want to use other people's credit card details for the purpose of transaction and payment. The reason, because you don't have your own money, so you use other people's money. Basically, it's a theft. So this is also very rampant. Yeah, when it comes to cybercrime and online purchases. So what you see in the right picture, this is a very young man who is now the Minister of Communication and Digital Malaysia, Minister Fahmi. So he just become a minister less than a few weeks, maybe 2 or 3 weeks now. So he also has a very high concern when it comes to data protection. He already instructed one of the company, which is AirAsia. We all know AirAsia. Maybe we used to buy the ticket. You want to come to Malaysia, Ibu Siti, you can get airline ticket by AirAsia, very cheap. That's why people like it. However, with this news, then we realize that the personal data may not be safe. That's why the ministry had already instructed to inspection over AirAsia due to the data leak, because there was a data leak in AirAsia. So we don't know, maybe our data is already elsewhere. So what I want to say is that this is showing that Malaysia is now a bit changing, moving faster with this new government. They are looking at it more seriously. I mean, well, they were also serious before, but now it seems that they don't want to delay. Okay, now I think I'd like to keep very fast on this background. We all know why we are here, because we are already in the Society 5.0, or something for the industry, they call it Industry 4.0. Where we are now have involved the massive transactions, massive use of digital technology as well as the data. So this is where we are looking at now. Super smart society using big data, IoT, artificial intelligence, and then everyone has a gadget, and then using all the for all part of life. So this is what we call as digitalization. So this digitalization, of course, can come up with cyber risk. We call it as a cyber risk. Why a cyber risk with this data? Meaning you tend to exchange or to expose more data, yeah, and using cloud here and there, because now we need cloud. We need cloud because you have so much data. Why do we have so much data? Because you keep on recording everything with your mobile. Yeah, everything you see, you take picture, isn't it? Before eating, you take picture. After eating, you take picture. 3 times you eat every day. 3 times 2, you take pictures. So lots of pictures in your phone. It cannot take all the pictures. Whatever you do, you take pictures. Then everything that you saw funny, you want to write it in your social media, or you want to comment in TikTok or Instagram. So you have so much data that you input. Therefore, now our tool will not be able to accommodate all this data. Therefore, now we are in need of cloud service. What is cloud service? It is a storage service beyond our perimeter. Meaning now we are using a third party data storage facilities in order to store our data. And be mindful that our data is also, some of them are very important data. Yeah, very important data, very crucial, confidential, sometimes personal, and to some extent it may be very secret data, especially if you work with some, agencies and so on. So now consider all this. Now we have a cyber risk. The risk of the data being misused, being exposed, is increasing. That's why in one of the very important annual survey by PricewaterhouseCoopers in 2022, they highlight what is the biggest thing that people worry, and the audience or the participants, of this global survey is the CEO, chief executive officers throughout around the world, and they have this answer. You can see what is the top of the threat. Top of the threat here is cyber risk, meaning now people are worried. What will happen to my data if anything goes wrong? What will happen to my data if I lost my mobile phone? What happened to my data if someone discloses my password? You have that big worries because everything is there. That is why now we know why data protection is very, very important. And now in all part of our life, both personal and professional life, we are digitizing all those information, especially after pandemic, online learning, online work, online meeting, online dating, all online, online seminar, online class, and then you are using map to travel, your eKTP as well as the certificate now being stored digitally. All your payment, everything is data is getting big and bigger and massive now. That's why people now start to get worried about the privacy of their data. Should I change my mobile phone? Should I change my password? They get worried. This is one of the statistics. We have so many of them. Okay, but people are actually asking who is interested with your data. You never know. There are people out there who will always be interested to get your data. Don't ever think that people out there are all nice. They don't need your data. No, they are going to get your data and they're going to sell it. They're going to use it for commercial purpose, or maybe they want to use it to fake identities. They want to know where you are. They want to control your life. So this is all happening. I write there in the left side, there are 3 categories of people who will pursue your data: big brother, big data aggregator, and big fans. Big brother means those people who always keep watching you. It may be government, it may be non-government, and so on. Big data aggregator is all the business entities who try to get your data in order to sell the data to the advertisers. That's why now, from time to time, you will get messages, right? You get messages by SMS, you get messages over WhatsApp, you get email. They are offering you goods and services. How do they do that? Do they do it randomly? No, they don't do it randomly. They already know that you may be interested. For example, you keep on looking when you open internet. You always the first thing you will look for news about football. football, everything football, every time football. So the computer will record that, your profile, that you are a football man. So everything, all services, product related to football may be potentially offered to you. So this is how they profile your data. This is what we call as big data aggregator. Last but not least, we have big fans. These big fans, I don't know if anyone here has followers, over 1,000 or 10,000 or 100,000. Who are these people? You never know. They are big fans. But then what happens is, whatever you do, they will know. Yeah, they want to know where you go. Oh, this weekend you say you want to shop at certain mall. Then they will wait for you, especially if you are a high-profile celebrity and whatnot. So these people will, to some extent, contribute to the attack, to the breach of privacy, which you don't want. Therefore, these are situations that your data is very, very vulnerable. Now we talk about privacy. What is privacy? Privacy means you want to have right over your life, enjoying your life, to be left alone. But how can you be left alone if every time people watching you, every time people following you? Because you yourself open yourself to the world. So you cannot expect some privacy, especially celebrity. Wherever they go, people will recognize him or her. That is risk. That is the risk you take as a celebrity. You don't blame people for following you and wanting to get your signature or autograph because you are a celebrity. Or maybe you are a favorite lecturer in USU. There is also a risk. You become a favorite lecturer, so everyone will follow you. Everyone will want to know about you. So that is part of life. To some extent, we should have some control to our own life. That is what we call as right to privacy. Everyone has right to privacy. It is a very inherent right. It is right recognized in our religion, in our tradition, and even in our constitution. Now the problem is, with the massive use of digital technology, this right to privacy is being sacrificed or being ignored because of some reason, either because of your own or maybe for other people and so on. So this is where the gap is there, starting the conflict, and why we need the law. So you see from this, for example, many of incidents, university. This is in Malaysia, University Malaya, then telco, telecommunication data, Malindo Air, UITM is another university, Patients, National Neurology. So many data in so many agencies. You cannot avoid. Your school, your university, hospital, telco, bank, and so on, they all have huge amounts of data. So they are all potential targets to data breaches. Okay. And the good thing is that now data privacy is already a global agenda. It is not only country's agenda, but it's a global agenda. Everywhere in the world, they already regulate. Here in my slide, this is an old slide, for ASEAN countries. Now it should be 5 already with Indonesia. Okay. This is the global map. Indonesia is still red, meaning at that time, Indonesia is still in preparation. Now should be blue, meaning already having the law. Okay, and then some other big countries, Saudi Arabia already has the law. India almost, but not yet, only almost. So more and more countries now have the personal data protection law comprehensively. Now very interesting, China already has one, but United States doesn't have one because they have sectoral based law. They have sectoral based means they have data privacy in relation to banking. They have data privacy law in relation to education, in relation to healthcare, and so on. So it is sectoral. It is not comprehensive. Here, what we are talking about is the comprehensive law. It is very important to have a comprehensive law because data everywhere it is the same data. So you cannot have a different standards of sectoral laws. Okay. So now let me quickly introduce you about Malaysian law. Okay, there are so many information here. What I want you to highlight is okay, PDPA only applies to commercial transaction. That's what I want to say here. Yeah, commercial transaction. So if it is not commercial, so it is not applicable. Yeah, maybe it's not very clear here, but what you can take, number one is PDPA only applies in Malaysia for commercial transactions. So if it is not commercial, for example, what? If it is only used between, for example, in religious program, religious events, or maybe charity events, this is not considered commercial. Okay, but for other than that, it will be commercial. Then also another important, okay, this is what I say commercial transaction. Then you see here, the one I circle here, this PDPA not applicable to government. So in Malaysia, even though the law is already there since 2010, but the law only applies to private sectors, not government sectors. This is a big difference, yeah, between Indonesia and Malaysia. In Indonesia, the law covers not only private, but also government sectors. What about other countries? What about those other big countries? Do they separate the law? Most of the countries, they don't separate the law. So they actually have one law for both government and private. So Malaysia somehow is doing it differently. Which one is better? In my opinion, because it should be covering all for all. It should be covering for all, yeah, private as well as government. Yeah. Okay, next. Okay, this is the summary of Malaysian law. It regulates the processing of PII, meaning personal information in personally identifiable information in commercial transaction. As I said, so if it is not commercial, it is not applicable. There are new sets of obligations. I think I will skip this one because it's also mentioned in the next. Subject data. This one I took the poster from the government's website. Rights of data subjects. What are the rights of data subject? Number one, hak untuk menghalang pemprosesan bagi maksud pemasaran langsung. Direct marketing. So for direct marketing, people may reject, may refuse. You cannot use it for direct marketing until you get the consent. Yeah. So now you cannot easily use people's data in order to do direct marketing. So for people who are used to do direct marketing, direct call, then we have to consider changing the business process. You don't do that until you get the consent from the people that your data will be used by us in order to do direct marketing. Second, hak untuk mengakses ataupun right to access. So people should have right to access their own data. For example, you want to know about your data in your university, then you should ask university, and university should give you the access. Okay, we are using your data, which is what? Which is this data for what purpose? That is called hak untuk mengakses. Hak untuk membuat pembetulan. So if the data is not correct, people should be allowed to correct the data. Yeah, this is very important because if you don't correct the data, then it may be useless. Okay. Hak untuk menarik balik persetujuan. This is very important. You already give the data for in the past, but then you want to withdraw. Yeah, you can do that. Which means if the data, if the consent is already withdrawn, excuse me. If the consent is already withdrawn, so the people should not would not be able to use your data anymore. You see now, with this kind of rights, people get power. Consumers get power. Yeah, enforcement, empowerment of consumers. So konsumen diberikan diberikan kekuatan ya untuk menentukan ya to determine whether they can be whether they should allow the data to be used or not. Also, they can stop the use of data if it is used to cause a problem. For example, there are people or there are companies who keep on calling you giving you offer. Sir, this time for November we have this offer. Go to our hotel. Yep, 50% discount. Okay, tak apa. All right, thank you. Then following month they got same call again or same message again. Then January, then February, then the person asked this hotel, look, I don't want to receive any more call from you lah. It's too much. If I want to go to your hotel, I will go to your hotel. You don't need to tell me, you don't need to offer me and send me with so many commercial advertisement. Then the hotel, for example, then the hotel say, no, sir, you already approved that we can call you because your name is here in our database and we can call you. You already give us your consent. When was it? Last year. Then the person can say, no, now I want to withdraw my consent. Yeah, I want to withdraw my consent. You should never call me again. And if you call me, I will complain to you, and it can be a criminal offense. Yeah. So that is why the consumers will become empowered with this. Yeah, menjadi lebih memiliki kuasa ataupun power untuk menentukan for whether data should be used or not. This is one of the effect of the personal data protection law in Malaysia. This is the summary of the principle under the PDPA, the Personal Data Protection Act in Malaysia. So number one is general principle, meaning if you want to collect data, you must get consent, and it should not be taken too much. You want my data? Why? You should ask. You should ask. Yeah. Sometimes we want to buy pizza. Buy pizza. Then before I buy pizza, then people ask, okay, can I get your IC number? Can I get your KTP number? Why you need my KTP number? I just want to buy pizza. I just want to buy pizza. I will give you my credit card or my debit card or my money. Sometimes these people, they want to fish as much data as possible. This one is not necessary. We call it excessive. If people don't like, then they should not give. Yeah. So with the new law in Indonesia, all of us, we should ask question. When there are people asking you, can I get your phone number? Can I get your nomor NIK? Is it NIK ya, Bu Siti? Nomor induk kependudukan. Yeah. Sometimes they ask you NIK, nomor SIK, nomor NIK, or nomor KTP. So you can ask for what purpose? Is it really necessary? If it is not necessary, then it should not be given. No, the problem is people will ask you this thing. And then also under the law should give you notice and choice. They should inform you why they need the data, for what purpose, how are they going to use it, are they going to disclose it to other people or not, how long they are going to use it. These all will have to be informed. That is why now, after this law, we need to have what we call as privacy policy. You can go to any website. If you go to any website, you will see down there at the bottom of the page, privacy policy, kebijakan privasi. Now, please, for university, you should also be prepared for the university because you are collecting data of students. Then students may ask you, what do you use the data for? You better be prepared. So I can advise. I believe you have had some already being prepared. Yeah. Because this is what the law wants us to do. But don't worry, the law in Indonesia give you 2 years, 2 years to be prepared. So these 2 years we must prepare. Yeah, I can give more advice on what to be prepared. In these 2 years, there are things to be prepared. For example, preparing your privacy policy, changing your form, then the issues of data policy regarding recruitment and so on. Lots of things, yeah. Also disclosure, the data should not be disclosed easily. Then security, how do you keep the data? Under what security? Are you using some technologies? What kind of technologies? Now you should put it in your business process. When it is being audited, then it should be mentioned. So this has become like auditable, practices. Then after that, retention data. How long you're going to keep it? What happened if you already done with that? Should you still keep it or not? And so on. Data integrity means how you make sure the data is complete. You don't collect data which is not complete. You don't collect data which is not accurate. You don't collect data which is not up to date. Okay, so this one all will be needed. And last but not least is access to data, meaning people should be given access when they need it. So all these are the principles of data protection in Malaysia. This is the main rules under the PDPA in Malaysia. So if any of this rule is infringed, then it can be a criminal liability. Yeah, as a maximum 300,000 ringgit. How much is 300,000 ringgit? Times 3,500. Yeah, one ringgit now is 3,500. So I think some 10 billion, yeah? 10 miliar, 10 M maximum. If I'm not mistaken lah, yeah, 300,000 times 3,500. That is the maximum fine, denda maksimal, yeah. Penjara also can happen if it becomes, especially to the person or the staff who is liable. Maximum 2 years, ya, 2 tahun penjara. So this is the ancaman pidana, ya, ancaman pidana under the PDPA. So Ibu Moderator, how many more minutes left for me? If I can check.
Already finished, but we have 5 minutes to go.
Okay, 5 minutes injury time, yeah. Thank you. So I think I already mentioned to you the main principle, which is hak-hak data subject atau hak individu, as well as the principle. Under this one, you see the offenses, yeah, ancaman pidana or kesalahan pidana under the PDPA. If you breach data protection principle or you fail to register. So in Malaysia, yes, you have to register. You have to register. This is important. It is annual registration. So the government can control, yeah, and also unlawful collection. If someone, for example, someone go to the bank and ask to get the data of the customers, this is unlawful. This is unlawful. Or unlawful sale of personal data. For example, somebody work with a company, with insurance company, and then they collect all the data and then sell to third party, to other people. Yeah, this is also a crime. Okay. Enforcement, it's okay. I'll skip this one. This is example of enforcement. In Malaysia, data protection officer is not compulsory, but in Indonesia, yes. Which means in Indonesia, companies will have to have a specific officer to deal with the data protection. That's why our student of USU, you better learn about this. So this will be a new market, a new job market created by the data protection law. If you understand about the data protection law, they can recruit you as data protection officer. I will be very quick. I think I want to show you the difference. Okay, GDPR. Malaysian GDPR is a European law. Is it applicable in Malaysia? Yes, in certain matter it is applicable. If the company in Malaysia is advertising or is targeting customer from Europe, so in that case GDPR is applicable. You should know the do's and the don'ts. Similar thing to Indonesia. If any Indonesian entity or organization or company targeting or advertising or dealing with customers from Europe, so you need to understand some aspect of the European law, GDPR. No, this is my last slide. I just want to show you some. This is some cases, yeah. Just 2 minutes, last 2 minutes. This one in Germany, the police was found liable. Why? Because bukan polisnya, tapi satu orang oknum. one officer, police officer, has used the data in the police database for his own personal use. Yeah, this is wrong. So if any police officer go to the database and then he collects some data and then use it for his personal purpose, this is already wrong. This is not Malaysian law, but this is German law. I just want to show you how the law applies in some countries. So similarly, if somebody who is working in hospital and then try to get some data from the hospital about patient, then he used that data for his private purpose, personal purpose, that is also wrong. Yeah, that is wrong. So both the hospital can be wrong, can be liable, the person will be liable. Okay, so this is example only. And you see there is a denda 23 juta, yeah, 23 million fine for this police officer. This one in Spain. In Spain, you know, we have CCTV, right? So some of this picture in CCTV, they are private. Should not be open to public because it is for your own purpose, and for security. For example, in USU, you may have some CCTV. For what purpose? For security or for some reason. So it must be used only for that reason. You cannot then suddenly share to people. So in this case, some picture from or some video from CCTV was spread over WhatsApp and online media. So the owner of that CCTV was liable. Yeah, the shop or the place where the CCTV was there, they are liable to pay 49 million rupiah, yeah, or 3,000 euro, or 49 juta, in term of denda, yeah, denda 49 juta. You see, it can be very serious. In Singapore, because of security breach, keamanan data, then causing some data to be breached by hacker. So the denda 367 juta, 367 million rupiah. In Poland, this is again European law, just now Singaporean law. In Poland, yeah, what happened was privacy policy not complete, denda fine 49 million. Last but not least, this is my last case. In Malaysia, someone who worked with Malaysia Airline, with the airline company, she actually took the picture of the boarding pass. You see the right picture here is boarding pass belonging to these two people. This couple, they are celebrity couple, artist, celebrity couple, but they were not married at that time. So this was made as a story and highlighted in Facebook. Then they are not happy because this boarding pass was supposed to be confidential, private, but then it was spread over by an officer from Malaysia Airlines. Therefore, Malaysia Airlines was sued. They were found to be in breach. However, this case was settled outside the court. So we better be very careful when you spread any info, because they spread this travel information of other people over Facebook. So this become a breach of privacy. I think with our law currently in Indonesia, then you also have similar situations and you better be careful in doing that. So my last point here, data protection, personal data protection law has actually changed the whole landscape. It affirmed the privacy expectation, meaning now we feel we have privacy. Second, it is business as usual no more, meaning you have to change the business process. And then it's a culture of respect. You need to respect transparency when it comes to data of people and not to delay the program. Program means you have to be prepared, for university, for hospital, for any organization. Be prepared, in order to conform with the law within 2 years. Indonesian law gives you 2 years. That is all from me. Thank you so much. Thank you for following and thank you for having me. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you for insightful information for your presentation. Before we go to the last speaker, I'm going through some housekeeping to ensure that you can interact with myself and the speakers. First, if you ask to the presenter a question, please use the chat feature in this Zoom webinar. You can also submit a question via the chat feature on the Zoom platform for decision for the presenter to answer after this session. If you experience any issue in hearing studio webinar, please contact our administrator. Their support team will help you troubleshoot any issue. As we know that from the presentation, we have got a PDPA in Malaysia. So we have moved to the PDP in Indonesia for Indonesian scope. And we should know that in existing regulation relating to personal data in Indonesia, we have an expert in Indonesia. So we invite Dr. Jelly Leviza SHM Home. For presentation, I will let's take a moment to introduce our last speaker. She is a lecturer from the University of North Sumatra. She earned Doctor of Law from the University of North Sumatra in 2006. And he has a publication which is Law Development in Digital Society Era in 2021. And you can also see the very easy to his paper, both national and international scope too. So to Mr. Jelly Leviza, the screen is yours.
Thank you, Nisa. Nisa is my ex-student. Now he is my colleague in this faculty, and now she is the boss because she gives me this opportunity, and she can stop me anytime she wants to solve. Okay, ladies and gentlemen. First, I would like to say, Honorable Dean of Faculty of Law, Dr. Mahmud Siregar SHM Hum, Honorable Head and Secretary of Magister Program in Law, Prof. Saidin and Dr. Mahmud, the Honorable Lecturers and all the amazing students here. Assalamualaikum, good afternoon, ladies and gentlemen. First, I would like to say thank you to the organizers of this international webinar for giving me the opportunity to talk about or to explain legal protection of personal data in Indonesia and a comparison with some other countries. My name is Jelly Leviza and I am a lecturer of Faculty of Law, University of Sumatra Utara. Ladies and gentlemen, I will, at the beginning of this presentation, I will explain the definition of data referring to several dictionaries like Oxford Dictionary and KBBI. And then definition of data by using etymologically and also legal definition of personal data. According to Oxford Dictionary, that data is, please. Yeah. Facts and statistics collected together for reference or analysis. While according to KBBI, that data is information that is true and real, information or real material that can be used as the basis for the study, analysis, or conclusion. With regard of these two definitions, it can be concluded that data, according to the Oxford Dictionary and KBBI, is useful for analysis, reference, or even making a conclusion. Next. Belum. Etymology. Yeah. On this slide, I will explain the meaning of data etymologically. The word data is the plural form of Latin word datum, which means the thing given. The word data comes from the Latin words. The data is the plural form of datum. So don't use the word data because data is already plural. Some of my students in their research using the words berdasarkan data-data. That is not correct. The correct one is berdasarkan data because data is already plural form. Finally, we can see that etymologically, the meaning of data is a record of collection of facts. This definition of data is more relevant to the concept of personal data we are talking about. Next, please. Based on law number 27 of 2022, that personal data is any data regarding individuals who are identified or can be identified either separately or in combination with other information, directly or indirectly, using an electronic and non-electronic system. So as we can see that personal data consists of 4 elements. Firstly, related to individuals. Secondly, identified or can be identified. Thirdly, separately or in combination with other information. And lastly, it can be used with electronic or non-electronic system. In the pictures below, we can see some examples of personal data contained in such as driver's license, passport, saving account book, ATM card, and also email address. Next. Ladies and gentlemen, there are 2 types of personal data based on the law number 27, year 2022. It called specific personal data and general personal data. We can see the provision of these classifications based on Article 4 of Law number 27, year 2022. Specific personal data consists of the following items. First, health data and information, biometric data, genetic data, criminal records, data of children, personal financial data, and any other data in accordance with the relevant laws and regulations. While general personal data includes such as full name, gender, nationality, religion, marital status, or combination of it. Next. The protection of personal data is based on the right to privacy. As we can see on this slide, the right to privacy is the freedom for a person to decide whether he wants to share or not with the others about himself. This includes the personal information. Personal information includes a wide range of information or an opinion that could identify an individual. The right to privacy protected in national and international law in the field of human rights. Over 150 national constitutions mentions the rights to privacy. Next. Now, ladies and gentlemen, in this slide, I'm going to show you how is privacy in a view of a great philosopher named Immanuel Kant. As we know that Immanuel Kant is a German philosopher, and he was one of the important Enlightenment thinkers. According to his teaching, that privacy is all moral agents should value privacy and individuality for themselves and others. Next. Then how is the relationship between privacy and human rights? In this slide, at least there are 5 points that can be stated here to answer that question. Number one, privacy is a fundamental or essential right for human autonomy. Number two, privacy is related to human dignity. And privacy is the right to enjoy life. Privacy also the right to privacy is the basis for suing in the event of a violation of privacy. Privacy can be the foundation of which in many other human rights are built. The example of privacy right is the right to know what personal data and entities are collecting about, and the right to know if businesses are selling our data and to whom. Next. Okay, we'll see there are several international legal instruments that recognize and regulate the rights to privacy, including Universal Declaration of Human Rights 1948, the International Covenant on Civil and Political Rights 1966, United Nations Convention on Migrant Workers, UN Convention on the Rights of the Child, American Convention on Human Rights, and African Union Principle on Freedom of Expression. Next. Okay, here we can see how the UDHR, or Universal Declaration of Human Rights, regulates the protection of privacy rights. We can see in Article 12 here of the UDHR, it is stated that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attack. As we know that Universal Declaration is one of the most significant legal instrument on international law, together with International Covenant on Economic, Social, Cultural Rights and International Covenant on Civil and Political Rights, they call the International Bill of Human Rights. Next. Why is privacy so important? There are at least 4 points that explain why privacy is important. Firstly, privacy gives us the power to choose our own thoughts and feelings. The rights to be let alone, for example. Secondly, privacy gives us the power to choose to whom we want to share. And thirdly, privacy protecting information we don't want to share publicly, such as health or personal finance issues. And lastly, privacy protecting our physical security if our real-time location data is private. As we can see in this picture, sharing the real location is depend on you whether you want to share it or not. Next. So bukan itu. Pancasila. Okay, I will continue. Pancasila as a philosophical foundation for protection and personal data. We can see that the second principle of Pancasila said just and civil humanity. This principle is the philosophical foundation for personal data protection in Indonesia. Next. Okay, sociological basis for personal data protection. Protection of personal data equal to protection of private rights, while protection of private rights equal to protection of human rights. Next. What are the impacts of data leakage? One example of a case can be seen here where a data leakage occurs from ATM receipt. It means personal data can be used to break into financial account. So you better not leave your ATM receipt behind because it will make you into a risk. Misuse of personal data for illegal online loans. borrowing money by other people who claim to be the owner of the data, there was terror for a refund or interest. Leakage personal data can be used to map the profile of the data owner, for example, for political purposes or advertising on social media. Next. Now we can see sextortion. Sextortion is a serious crime that occurs when someone threatens to distribute private and sensitive material if the victim don't provide the image of a sexual nature, sexual favors, or money. From this picture, we know that the highest sextortion in Asia occurred in Indonesia. About 80% of the sextortion happen or occur in Indonesia. Next. Ladies and gentlemen, there are several cases related to data leakage as can be seen in this slide. Personal data leakage supposedly happened in Ministry of Health, Ministry of Communication and Information, and Central Bank of Indonesia. Next. According to the CNN News, the biggest data leakage in Asia occurred in Indonesia. So we better careful on this issue. Next. According to UUD 1945 or 1945 Constitution, every person has the right to protect himself, his family, honor, dignity, and property under his control, and has the right to feel safe and protected from the threats of fear to do or not to do something that is a human right. Next. The Indonesian government on 70 October 2022 actually have one legal instrument. It called Law Number 27 of 2022 concerning personal data protection law. The law is a mandate of Article 20H, paragraph 1 of our Constitution. The objective of Law Number 27 of 2022 is to protect and guarantee the basic rights of citizens related to personal protection, guarantee to get service from corporation, public agencies, international organization, and the government. Next. And then Law Number 23 of 2006 concerning population administration as amendment by Law Number 24 of 2013. According to this law, everyone is prohibited from disseminating personal data. And then Law Number 11 of 2008 and Law Number 19 of 2016 concerning information and electronic transactions regulate the use of any information through electronic media. Use of a person's personal data must be done with the consent of that person, unless there are other rules. If there is use of someone's personal data without the permission, then the person whose rights have been violated can file lawsuit for the losses incurred. Next. Indonesian government also has Indonesian government regulation number 71 of 2019 concerning implementation of the electronic system and transaction. And then there is a regulation of the Minister of the Communication and Informatics of the Republic of Indonesia number 20 of 2016. Next. Okay. Now, ladies and gentlemen, we are entering the last part of my presentation on comparative law. Next. Here we can see General Data Protection Regulation. The General Data Protection Regulation, or GDPR, is a European privacy law that became enforceable on May 25, 2018. Applies automatically in 27 members countries of the European Union and the European Economic Area. The goals of this GDPR is to protect the personal data and privacy of individuals living in the European Union and on the EEA region, encourage more responsible use and processing of personal data. Next. Now we can see a comparison between legal protection of personal data in Europe and legal protection of personal data in Indonesia. In European Union General Data Protection Regulation, or GDPR, personal data means any information relating to an identified or identifiable natural persons or data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, psychological, genetic, mental, economic, cultural, or social identity of that natural person. While we can see that law number 27 of 2022 concerning personal data protection in Indonesia state that any data regarding individuals who are identified or can be identified either separately or in combination with other information, directly or indirectly, using an electronic and non-electronic system. So we can see there is no the words an electronic and non-electronic system in European Union General Data Protection Regulations. It is different with law number 27 of 2022. Next. Number two, the comparison between GDPR and law number 27 is GDPR has an extraterritorial effect because this regulation applies to all parties everywhere, including those outside the European Union, as long as they carry out activities related to data processing from individuals living in the European Union region. While in law number 27, we can see that applicable for legal actions outside the jurisdiction of Republic of Indonesia, as long as they give rise to legal consequence. So there is a common regulation in here. Next. Next, maybe. Okay, Singapura. Oh, yang Facebook. Okay, Facebook itu. Okay. In this slide, ladies and gentlemen, we can see how there are various social media fines for personal data breach, like Facebook fine 70 million euro for breaching EU data privacy laws, and then Google fine 150 million euros, and then Irish data regulator fines WhatsApp. Next. On this slide, we can see how the personal protection law compares between Indonesia and Singapore. Number one, legal protection regarding personal data in Singapore. There have been personal data protection regulation since 2012, while in Indonesia, the regulation of personal data starts on October 17, 2022. Number two, the protection of personal data in the public and private sectors in Singapore is differentiated. Public bodies or government of Singapore are bound by the Public Sector Governance Act 2018. Meanwhile, private parties are bound by the Personal Data Protection Act 2020. While in Indonesia, we can see that personal data protection under the law of 27 year 2022 applies to everyone, public bodies and international organizations. Thirdly, penalties for unauthorized disclosure of data is imprisonment for up 2 years or a fine of $5,000 or both in Singapore. But in Indonesia, penalties for unauthorized disclosure of data in the form of administrative sanctions, including fine, compensation, and imprisonment, or a fine of up to 5 billion rupiah. Lastly, disclosure of personal data can be done if there is an emergency threatening the life, health, or safety of an individual or other individuals. In Indonesia, disclosure of personal data can be done in the interest of national defense and security, interest in the law enforcement process, public interest in the framework of administrating the state, and etc. Next. Okay, this is the last slide, and on this slide we can see how the personal protection law compares between Indonesia and United States. Legal protection regarding personal data in the US is already since 1970, while in Indonesia this regulation was published on October 2022. Secondly, legal protection in the US, legal protection of personal data is sectoral, such as Electronic Communication Privacy Act 1986, the Health Insurance Portability and Accountability Act 1966, and etc. While in Indonesia, legal protection for personal data is sectoral, until law number 27 of 2022 concerning personal data protection, which regulates comprehensively. Thirdly, there is no single independent agency has comprehensive authority for personal data protection in the US. Several institutions have authority according to each of the laws mentioned above. This can be a problem in the terms of integration and coordination. In Indonesia, we can see that personal data protection is carried out by an institutional designated by the president. And then lastly, applies differently in legal protection in the US applies differently in each state. The New York Privacy Act is one of the most comprehensive of its regulation. And we can see that law number 27 of 2022 valid for all regions of Indonesia. Okay, ladies and gentlemen, that is my presentation. Thank you for your attention, and I'm giving back to the moderator. Thank you.
Thank you, Mr. Dr. Jelly Levija has been presented this informative presentation. So we are going now to the, okay, we are going now to asking question session. Here's the Yusen Saidi Sasa from Indonesia USU, raise hand to ask directly. Sir, Mr. Hussein, you go directly ask the questions.
Yeah, Miss.
Okay. Okay, we will be pleased to giving the question to Mr. Sony Julhuda or Dr. Jelly Levija.
To Mr. Sony Julhuda.
Okay, yeah, the screen is yours, sir.
Yeah. Okay, thank you for giving me opportunity to ask. As we know, Malaysia is a kingdom Now I'm going to ask Mr. Soni Zulhuda. What is the basic comprehension of personal data protection conceptual framework, standard, and legislation process between Malaysia and Indonesia? The second one is, what is your view on protection of personal data and human rights in the cyber era? According to what Mr. Soni Zulhuda said, there are three things called privacy, namely anonymity, solitude, and secrecy. Thank you. Back to moderator.
Okay, thank you, Mr. Hussein, for the question. So your time for the answering, so Mr. Dr. Soni Zulhuda.
Thank you, Ibu Siti Khairunisa, and thank you, Bapak Hussein, for the question. The first question asked me about comparison between Malaysian law and Indonesian law in personal data protection. Yeah, there are some areas where the two laws are quite different. Number one is about the applicability. Yeah? Malaysian law is only applicable to private sectors and non-government sectors. So government is not subjected to it. But Indonesian law, it covers to all, just like what Bapak Jelly was saying in the presentation. Indonesian law covers all the sectors, including government, private, public bodies, institution, and so on. Also, when it comes to legislative process, enforcement process, there's also a difference. In Malaysia, not everything will be going to the court immediately. So in Malaysia, we have this mechanism, which is a co-regulatory mechanism. Co-regulatory here means not only the government will decide and will determine, but also the industries. Yeah, the industries will be given some room or some space in order to self-regulate themselves. This is what we call as data user forum. We call it data user forum. For example, between banks, we have so many banks in Malaysia, so they will create their own forum, data user forum for banks in Malaysia. So when there is a problem between banks, then they will sit among themselves, then they can agree on some standards and procedures. Then also when it comes to enforcement, not all cases will go to court immediately, because some cases will be settled under executive action. Yeah, meaning the department can issue summonses or can issue enforcement notice. So you don't need to go to court. And if this can be settled, then maybe you will pay lesser fines. Yeah, lesser, not much. But if you are not happy, you can bring your case to tribunal. So in Malaysia, we have smaller tribunal, Mahkamah Kecil tribunal, in relation to personal data protection. So this is in order to make it easier if you have dispute when it comes to data protection. So I'm happy to share with you that I'm part of that tribunal. Yeah, I'm part of the member of tribunal. So if there's any case, we will sit down on ad hoc basis, and then we will discuss on the dispute. Okay, there is some comparison between Indonesia and Malaysian law, which I believe each has pro and cons. Yeah, some strength and weaknesses. Each for Indonesia, each for Malaysia. But what more important is the enforcement. We should show seriousness when it comes to enforcement. Then the second question is about human rights. Yeah, I think data privacy, as what also mentioned by the other speaker, Bapak Jelly, yeah, is very much related, and in fact, coming from the idea of right to privacy. Yeah, data protection comes from the fundamental right of privacy, because everyone has right not only to life but to enjoy life. You can have life, but if you cannot enjoy your life, so it's useless. So one of the indicator enjoying your life is you are given freedom and respect in order to decide what you should do. So this is so much part of the law or right to privacy. Of course, when we talk about privacy as a human value, it may differ. What privacy is seen in Western values or Western community may be different with the privacy that we have in Eastern community, especially you're talking, for example, with different region, different religion, different tradition, but we agree on something very common. People must be given respect and freedom, yeah, to decide for their own life. How much and to what extent the freedom is, yeah, is different. Maybe between Malaysia, Indonesia, and freedom in China, freedom in United States, of course, different depending on the local circumstances. And also as Muslim, also there is also a limit to the freedom of the Muslim. So that's what I want to say. Right of data protection is very much related to the value of the universal value of human rights. Thank you.
Thank you, Mr. Sony Johuda. That's a very highlight to that you said that there's some cases between bank in many create the forum for the personal data. This is some like example for Indonesia, as we know that sometimes data leak in Indonesia, especially in the bank. When I got called from another bank who not my money is not saving in my bank, and she knows my name and my number. So I asked, she over promotion about credit card. So I asked, how do you know my number? How do you know my identity? As we know that the bank is keep a secret our identity. And I know that my account is not in your bank, so there is no solution. So that then, and they stop calling me again, and I give it a legal basis for the staff that make sure that you just keep it secret all the customer in your bank. That's all. Oh, okay, I'm so sorry. And after that, I give they're calling not back again. There's some example. So in Malaysia, they have a forum for personal data. So, and there's a highlight that I gave it. A small tribunal for personal data in Indonesia. They don't have the small tribunal, just like the others have a court. Some cases in the one court, just like that. No, small tribunal there is not available. Maybe the next be as the innovation for the new innovation for the personal data. Thank you, Mr. Sony Johuda, Dr. Jelly, Mr. Sony Johuda. We have one question from the chat box from the Miss Stella to Mr. Sony and Mr. Jelly Levija. A myriad of personal data protection regulation has been imposed on the public in the industrial era 4.0 worldwide, from the civil law legal system to the common law legal system. However, what are the main concepts in ensuring the most appropriate protection for personal data protection in the development of Industry 4.0 to Society 5.0 around the world? So, to Mr. Sony Johuda, the floor is yours to answer this question.
Okay, I will leave the much space to Bapak Jelly to respond after this. But let me just say very quickly, of course, there is no one single there's no one single solution for this data protection issues. And as we know, law alone is not is never enough. Yeah, law is necessary to regulate, but to regulate behavior. But remember, I think when it comes to technology, at least there are 4 elements that can help us to regulate. Number one, of course, we already mentioned the law. Law here like personal data protection law or data security law, ITE, and so on. And second is, of course, the norm itself. The norm is there, very important. We have to stick to the norm of the values that we been using, and not to forget these values. That is a very important ethical and and normative values, yeah, that will keep us behaving when it comes to personal data processing. The third one is technology itself. So we need to make sure the technology is also adopted. Yeah, if you want to protect data, for example, then you should then also offer some technologies that can help protecting securing the data. There is no use of us having a very good law, but then in practice, there is no good technology to help us, yeah, protecting the data. So technology is another element. And last but not least of the element is market force. Yeah, market force is also important. Yeah, we want to try to make sure that data breach should be costly. If people understand that data breach is costly, you have to pay for data breach, then people will not cost data breach. Because if you breach data, then you have to pay. So this is market consideration. Now, why people breach data? Because there is no consequence. People don't need to pay anything. People are not given any sanction and so on. Therefore, this behavior will continue until we see that the law is enforced and people will have to pay for this misbehavior. And that is my answer. Thank you.
Okay, thank you, Mr. Sony Julhuda. When we will be back to Mr. Jelly Levija to answer the question from Ms. Stella.
Okay, thank you, Nisa. Stella, thank you for your question. The best protection of personal data is involving everyone concerns and conducive government policies. The threat of severe punishment can also be a supporting factor. So it involves ourselves and our government. We must be concerned with protecting our personal data because we are the one who can decide whether we want to share our information or our data or we don't want to share it. And then law enforcement is one of the important factor. As we know that this law, I mean, law number 27 year of 2022 is still new. The government of Indonesia then must continue to socialize it so that public or community or our society can understand their rights and duties and their responsibility based on this law or law number 27 of 2022. There is some factors that affecting the implementation of legal protection of personal data in Indonesia. Thank you, Siti Hairunisa.
Okay, thank you, Mr. Jelly Levija. Okay, there's one who raised hand, Mr. Dedi Kusnadi, with directly delivered question for our speaker. The floor is yours, Mr. Dedi Kusnadi.
Okay, thank you, Ms. Siti. Thank you for Mr. Sony and Prof. Jelly for being here. My question is due to our theme today, 4.0 industrial revolution, we can say there is interconnectivity all over the world. I mean, no limit, limitless, borderless in human connectivity or human relationship. And there are some legal system in this world. For the main different, maybe I can say civil law or common law system in this world. The question is how we can to choose what kind of law enforcement we could apply to one case maybe rise in this borderless connectivity. I can say, maybe I can say one data set may be a crime in Indonesia, but in another country, that's not a crime. So, Mr. Sony and Prof. Zeli, please let me know. Please give me some explain to solve this question. Thank you. Thank you, Ms. Siti.
All right, maybe I choose Mr. Sony Julhuda first to answer this question.
Thank you. This question is basically back to the principle of public international law when it comes to choice of law and choice of forum. Yeah, it is always possible when we deal with something which is international in nature. It may involve several laws from several countries or several laws, yeah, in different countries. For example, you want to use some cloud storage service, yeah, cloud storage service, and this cloud storage service comes from Singapore, yeah, from Singapore. So the person who who maintain the service is in Singapore. Now by using the cloud storage, that means you actually store your data in Singapore. Yeah, your data is stored in Singapore. So if let's say now the data which belongs to you now is being stored in Singapore's facility. So what happens if there is any incident of data breach in that facility in Singapore? Yeah, so we have, because all this while we have learned under public international law when it comes to multiple countries issues, we have to look at the right forum. Right forum here means which court is actually having the power. Is it the court in Indonesia or the court in Singapore? So normally we will look at the implications. Yeah, where is the implication of this incident? Yeah, if the implication is felt in Indonesia, then the court in Indonesia can summon, yeah, the person in Singapore to attend the court in Indonesia and to answer, yeah, the accusation or the legal suit. In other words, the person whose data is being breached in Indonesia may sue, yeah, the company, yeah, who is in Singapore to come over to Indonesia. So that is possible. Why is it possible? Because the data which is breached belongs to a person or the person who is in Indonesia. However, at the same time, the court in Singapore is also able to deal with the case if the incident of data breach is considered an offense or is considered wrong in Singaporean law. Yeah. So in that case, it can also happen like that. It can also happen because the place of the offense is in Singapore. So in these situations, there are two possibilities. So it is up for us to choose which one we want to go. I mean, if it is really your choice. Otherwise, if it is a criminal in nature, then the law can apply without your choice. For example, the police may process the case in Singapore, and you cannot deny because it is part of their law. But if you want to sue under Indonesian law, then you may also do that. Yeah, especially in private suit, yeah, perdata, especially in order to recover your losses. So what I'm trying to say is that similar principle under the public international law will apply. Yeah, wherever the implication or the impact of the incident is felt, then that place will be having right of forum in order to prosecute the case. So this is very possible because data can come from anywhere and can be processed anywhere. Yeah, so basically that's what I can comment as giving an example. Maybe can be added by Pak Jelly.
Okay, thank you for Dr. Nijul Huda for the answering the question. That's one highlight words that I come from the Dr. Asad Prof. Sony Julhuda. Data came from anywhere, cases from anywhere. So we continue to Mr. Jelly Leviza.
Okay, thank you. Thank you, Mr. Dedi Kusnadi, for the question.
Thank you, Prof.
I think you are talking about pluralism. Pluralism based on the different legal system in this world. There is
Yes, for sure.
civilian legal system, common law, etc. Based on the field of international trade law, there is also pluralism. Indonesia has own regulation on international trade under international private law or HPI. The same condition with Malaysia, Thailand, Singapore, Germany, or even many countries. So the question is, how can we make a legal instrument so there is no conflict between different legal systems? The answer is, when there is a pluralism, so the solution is unification and harmonization of law. For example, in the field of international trade, there is United Nations Convention on International Sales of Goods 1980. That is a legal instrument in the level of international law that regulates in the form of unification. While in the harmonization law, there is a UNIDROIT principle. At this point, I mean, in the field of legal protection of personal data, we can see the example for GDPR or General Data Protection Regulation in Europe. General Data Protection Regulation in Europe is a kind of harmonization of law for all members of European Union. So the solution of different legal system is by using two ways: unification of law or harmonization of law. That is my answer. Thank you. I'm giving back to moderator.
Thank you, Mr. Jerry Leviza. That was there's two solutions for the law to adopt to law the law from the other country: unification and harmonization. That's one point to adopt a law from the other country. So I have one question for Dr. Associate Prof. Sony Huda. There's such interesting that we have known the Personal Data Protection 2010 come into force in Malaysia. What are the main challenges for the effect the personal data? The PDPA, what are the main challenges for PDPA in Malaysia?
Okay, thank you. Yes, we have the law already being enforced since 2013. So now it's almost 10 years. However, I must say personally that it is not very satisfactory, situation yet. There are a few challenges to be honest. Number one is about the awareness. People's awareness are still quite low, especially we are talking about rural people. People outside the cities, in the rural areas, they are not very familiar with this kind of data breach. They can be easily cheated. They can be easily misled by people who want to exploit their personal data. So from time to time, the government has been trying to enhance the awareness, but yes, it is a work in progress. Yeah, it is not yet satisfactory for now. Number one. Number two is the challenges of technology itself. Now, especially with the internet and the mobility getting more massive, the use of mobile apps and so on. So people tend to see only the function, only the function of the technology, but they forget the risk. Yeah, because every time you talk about technology, you must see the two sides of the coin. Yeah, one is the function or the benefit, the other is the risk. This is what people are not very fully aware. For example, they simply install all mobile apps from mobile phone, but they never know that each mobile apps, any apps that we use, they will collect data from our mobile phone. So have we actually done any control to that? So I doubt about that. So that is among another one is of course the challenge in enforcing personal data, because many data breaches actually come from outside Malaysia or outside jurisdiction. So that is also posing another challenge. We actually need some sort of international collaborations and international task force. At least we can start with ASEAN to make sure if we can help each other when it comes to tracing or tracking the possible source of data breach from outside the country. So I have mentioned some few. Maybe that is the situation now.
Okay, thank you, Mr. Sony Julhuda. As we know that.
Excuse me, Ms. Siti.
Yes, yes.
This is
sir.
one question contagious from my first question.
Okay.
Okay. So
Yeah.
okay. So thank you, Mr. Sony and Prof. Zelly. I can highlight that your answer is just in private area. As we know, the data breach can raise a crime. I know that private is person to person, people to people, but crime like extortion, like terror, like another crime it's risk the people lives. How about crime? Thank you, sir.
Yeah, I think crime. If the country is considers certain conduct as a crime, then they have they should empower it and enforce it under criminal legal system. Now the problem is, if for example it is considered as a crime in Indonesia, but the subject, the person and the accused or the culprit is not in Indonesia, right? If it is in Malaysia, for example. So now again going back to the same classic situations now. Do we have any convention, for example, on cybercrime, on data protection? Okay, of course, certainly for now there is no convention, there is no treaty in relation to data protection. But we already have some convention, at least one Budapest Convention on cybercrime. If the countries are member of Budapest Cybercrime Convention, then they will have some mechanism when they will be able to prosecute among themselves. They may want to get cooperation from the other country to get the criminal and get processed in the first country. So that is only possible if there is convention. If there is no convention, what can you do? You can only hope. But can you use the mechanism of extradition, for example? It depends. If you have extradition agreement, it may be used. It may be useful. It may not be useful as well, provided that there is already a common perspective and common definition as to what is covered under the bilateral agreement among the two countries. So we have some cases where certain countries will send their officers under undercover to go to other countries and to get the person arrested in other country and bringing back home. So that also can happen. But of course, we will not do that every time there is data breach from outside the country. So it is going to be costly and difficult. That's why I go back to my previous statement that it is very important to have some international platform where we can start working with each other, at least with exchange of information, and then and also coming further to mutual legal assistance in law and getting people to be, culprit to be processed. Yeah. So I think this is very important. So we need to consider for when it comes to Cybercrime Convention, however, Budapest is not the only choice, even though now only Budapest is in existence. But I think now United Nations, together with some countries, they already started speaking about creating new convention. There can be new convention on cybercrime. Yeah. Why is that? Because the Budapest Convention has been mostly dominated and promoted by European countries. So people don't feel like joining because they think that this is European sponsored. So some people, some governments feel that it will be safer or more neutral if the convention comes from United Nations. So now in the United Nations, they have some discussions going on for several years already in order to have a specific convention on cybercrime. So I think, like it or not, we need to look into this because cybercrime is a global crime. Data breach is a global crime. So if we only respond with a local law, then you will see it will not be very useful at the end. Thank you.
Oh, so we can take a conclusion that the data that interconnectivity data protection just cover the private area, but it will be more complex if we apply to Crime Act. Maybe that's the conclusion, I think, sir.
Yeah, if you are talking about international dimension, always when it comes to criminal system, it will be more complex because it talks about sovereignty of countries. Yeah, but when it comes to international private law, it will be more flexible. Yeah, so there is, if you are talking about internationally, but now I think in front of us we have so many problems. We have problem at international level, but we also have huge of problems at our own local and national level. That is, I think, our first priority. Yeah, our banks, our telecommunication, our electricity companies, our employers and schools, universities, they all hold our data in front of our eyes. Then I think this is the first thing. Yeah, we should make sure that they are not becoming another safe haven for data breach and for others. So they should in the first place make sure enhance their level of data security so as not to allow any more data breaches and data leakages in future. Then if we can settle at least in our local yards, then we can worry later about our international problem.
Okay. Thank you, sir.
Thank you, Dodi, for the question.
Okay, thank you, Sir Sony Julhuda, for the answering question. Maybe additional answer from Dr. Jelly Leviza. To make sure that your question from Mr. Dedi Kusnadi, please reply the question.
Oh, okay. Thank you, Ms. Siti. From this discussion, we can see that the data protection is just covering the private area, not in crime area. We know together that private area is person to person case, but in crime, that is more complex. This is one person, one citizen against one country, one government, one legal system. So need your explanation to give me enlightenment, sir. Thank you.
Mr. Dedi, can you sort your question, please?
Oh. Okay, sir.
Making it short, I mean.
This data protection is just cover the private area, not in crime area that more complex, I think so. Thank you, sir.
You are talking about sanction for the violation of personal data, Mr. Dedi?
Yes, sir.
Okay. If there is a violation or infringements of personal data, so the government of Indonesia under law number 27 of 2022 has regulated that there is a sanction of imprisonment for 5 until 6 years. And as we know that Indonesia is one of the country who applied the heaviest sanctions in the world. Compared to Netherlands, the sanctions in the form of imprisonment only apply for 2 years, while in other countries, the imprisonment is applied about 6 months. Then Indonesia is the heaviest sanctions, one of the heaviest sanctions in the world.
Okay, thank you, sir. So clear.
Thank you, Mr. Dedi.
Okay, we thank you for Mr. Jalil Rafiza. Maybe we have one question left, maybe from the chat. Due to the limited time for this webinar, to Mr. Sony and Mr. Jelly from chat room, please give your legal opinion and how should the responsibility of the government if there are leak of personal data due to the weak of IT protection from governments. For the example, the database from citizen from a ID card so could be hacked by third party. Please give your legal opinion. Maybe we turn on Mr. Jalil Rafiza.
Okay, thank you, moderator. Referring to the legal system theory by Lawrence Friedman, there are 3 elements relating to the law enforcement. Firstly, structure. It talks about competence of the legal institution or competence of law enforcer. And number 2 or secondly, substance or the materials of law. And number 3, legal culture. Legal culture is about how people perceive the law. Then to achieve a good law enforcement, these 3 components has to be giving a good contribution for each other. In the issues of legal protection on personal data in Indonesia, then on the first component, that is structure, the government has to emphasize or making a good trial or making a good process of law or law process. And then the government of Indonesia is already have new law on the legal protection of personal data. That is law number 27 of 2022. Then the last component is very complicated because it's about how people perceive the law. And again, like I said before, to make good achievement on law enforcement of legal protection of personal data, it involves our concerns. Then government again has to educate the people to these new legal instruments. So that is my answers. I'm giving back to moderator.
Thank you, Mr. Jerry Levita. We have the highlight point from your legal opinion. So additional from the Sir Sony Julhuda. The floor is yours.
Thank you. I think my take is very simple. As a matter of fact, my legal opinion will not matter. Does not really matter at this point. Why? Because as what Prof. Jelly was saying, we already have the law, which makes it very, very clear, obvious that it makes it a responsibility for everyone, and everyone here, including government, yeah, to make sure the security of our data. Data now becomes a very important resource. Data now becomes another source of power. So sovereignty of data is something of national interest. So who is the best to protect that if not the government? So we cannot get the government who is not ready, yeah, to protect our data, just like a government who is not ready to protect the people. So I believe our government should be in the first place. So if government is or fails, yeah, to do this, so something can be done or should be done against them. And as a matter of fact, under the new law number 27 year 2022, it does not make difference if the data breach come from private person or organization or companies or even government, then the law should apply. Yeah, the law should apply, because in this respect, the government is the main beneficiary. It's one of the biggest beneficiary of personal data. They are the one who process our data from our birth until our death, even after the death. Yeah, our data is being used and exploited by the government. So this is a big power, and always, yeah, with big power comes big responsibility. So we cannot let the government to be a safe haven. Let us learn from those countries, including Malaysia, where the law does not apply to government. I don't think this is ideal. Our law in Indonesia, the law in Indonesia is already ideal because it already covers government. So I repeat here, maybe my legal opinion does not matter because the law is already very, very clear that if data breach comes from the government, then the government should be responsible. That's why under the data protection law, we need this independent agency who can, yeah, process the legal action or legal dispute, even if it involves government institutions. Yeah, so I believe this is quite clear. Thank you.
Okay, thank you, sir.
I saw a hand raised by one of the audience. Was it Miss Stella? Just to propose to moderator, should we allow?
Okay, we will allow to.
Yeah.
To Miss Stella, giving a question. The last.
Okay. Thank you, Miss Helnisa. Just now I have asked about the myriad of personal data protection regulations.
Okay.
Mr. Sony have shown that to us about how the government made it, and to us it's the best. But now I want to ask, what is the important concept? Because if the third party have done not, if the third party have the something not good to us, how to finish it? Not only from the government, but the third party liability. Is it the presumed liability or absolute liability? Because I have shown Electronic Transaction Act in Singapore, it has shown the third party is the agent. So the agent must have the liability, but in Indonesia that's don't have. So this protection data, we have shown that law number 27 of 2022 that maybe have the liability. So how is in Malaysia? It is shown the good liability because the liability must be have the presumed liability or the absolute liability to the society, because we have done the to society 5.0. That's the big data, IoT, Internet of Things, and artificial intelligence. So which one the best concept that I make it the best concept of my question just now, sir? Thank you.
Okay, thank you. Our personal data protection law in Malaysia defines there are two different parties that may be liable. Number one is data user. Number two is data processor. Data user is, for example, our employers or our banks or our telcos. They are the one who actually collect our data. Or maybe airline company. We buy AirAsia ticket, for example. So AirAsia is the data user. So they are the main people who is supposed to collect to protect the data. Therefore, the law will make it very, very clear all the principles, the obligations against the data user. So if data user, for example, the AirAsia itself makes the breach or cause the breach, then it is very clear that the law will be used against them. Now you highlight about a third party. For example, somebody who is using the data, our data in AirAsia. Our data in AirAsia used by a third party. Yeah. So or our data in bank ABC used by a third party. Who is that third party? This third party may use the data legitimately because they may have contract with the data user. For example, AirAsia, they outsource the data to a third party. So third party will collect data, will also process data. Now the problem with our law in Malaysia is that it does not make it very clear what happened if the third party is the one who caused the breach. Yeah. Why? Because the PDPA in Malaysia has been too much concentrated on data user. Yeah, so it's very small part where we can use the law against data processor, especially on the issue of security. If they provide bad security, then they can be liable. But other than that, I mean, it is quite unknown. So if my data is breached by AirAsia, for example, so I can sue AirAsia or I can report AirAsia. But if my data is breached by a third party who is used by AirAsia, so I cannot use so much the law against them. However, I can sue them under the law of negligence. Yeah, I can always sue them under the law of negligence. This is a private legal suit, legal claim. Yeah, without law, without contract, doesn't matter. I still can sue them because they have caused my data to be lost and caused me some injuries. So the law is very clear, law of negligence. Yeah. However, I believe that the legislation should make it rather much clearer that even for the third party data processor, they should also be subjected to the Personal Data Protection Act. Now I want to comment about the law in Indonesia. Actually, the law in Indonesia is faring better than Malaysian law in this respect, because the law in Indonesia not only covers data user, or in the term is pengendali data, yeah, but also pemroses data processor. So I can see the law in Indonesia has more reflecting the the principles from the GDPR of Europe. It is stronger in that respect, meaning the law can be used not only against the data user, but also against the third party data processor. Now that is my brief comparison between the two. Why is that so? Because as we know, Malaysian law was enacted long before GDPR. We didn't really have a good benchmark at that time, 2010. But Indonesian law, I believe it has considered the recent developments introduced by the European GDPR. That's why it covers all these issues, including data breach notification, data processing officer, and also this data processors obligation. That's my comment.
Thank you, Sir Sony Julhuda. As we know that from your opinion, the law in Indonesia is not only cover data usage, but also data process data. And we have to reflecting from the European GDPR. So we have to concern in Indonesia. In Indonesia have not only covered the data usage, but notification breach data, process data has been made in Indonesia. Last but not least, as we know from the chat, from Mr. Deddy Kusnadi, our law personal data protection in Indonesia is better than Malaysia. From Prof. Sony Julhuda said, as we read at the chat forum. From Mr. Hussein Saidi Sasa, maybe the last, you give it last.
Thank you, moderator, for giving me opportunity. Okay, my question is, the first one is, as we know, data protection rules will be in Indonesia is in 2022. So I will ask to Mr. How about Malaysia? How about historical of data protection in Malaysia? The historical. The second one is there the biggest misuse or crime about personal data in Malaysia, and how the government solve that problem? Thank you.
If I am correct, you are asking about the history behind the enactment of Personal Data Protection Act in Malaysia, the history behind it.
The history
Yeah.
about
The history behind why we have this law, right? Okay, interesting, because the law has been there. In fact, the draft law has been there since year 1999. Yeah, the first draft of the law in Malaysia was first issued in 1999. At that time, Malaysia wanted to create a very competitive environment when it comes to information technology. That's why Malaysia created a multimedia super corridor. This is the area of technology, just like Silicon Valley in the United States back in 1996. So from then, the government of Malaysia came up with several draft of law. So now, then we had this Computer Crimes Act 1997, Digital Signature Act 1997, then Communications and Multimedia Act 1998, then Telemedicine Act 1997, and then we reformed the Copyright Act 1997. So not long after that, we wanted also to create Personal Data Protection Act in 1999. However, this law was met with lots of criticism, objection, as well as debates. So this law had been debated very, very long time, since 1999. And you can imagine until 2010, 11 years. So 11 years it has been there. So during these 11 years, there had been more and more cases where people's data are being misused by others. So because of that, the government wanted to speed it up, because more people are complaining about data being misused, especially by banking institution. At that time, the data has been misused and also has been exploited. Therefore, until 2010, finally, the law was then enacted. And now, after more than 10 years, the law was going to be amended. Yeah, the government now is preparing a draft of amendment. Some areas are going to be amended. So we will see how the law is being amended, hopefully not very long time after this. So it will be more efficient. What is the second question again?
Is there the biggest misuse of personal data in Malaysia, and how the government solves?
Okay, very interesting. There are many big data breaches in Malaysia. And some of them, the case is gone just like that. Disappeared. One of the biggest case is the leaking of 46 million data of telecommunication subscribers in Malaysia. Do you know how many people in Malaysia are? Not more than 30 million. But there are 46 million telecommunication data or telecommunication subscribers data being leaked, which means almost all the data of telco in Malaysia had been leaked to the internet. This is terrible, I believe. But then, to some extent, due to some technicalities, the case has not been settled. Another big case is actually relating to one of the airline company. So that one is already settled. The company has been fined, has been given a very huge fine. Not many cases actually coming up, finally prosecuted. So some cases, there are difficulty to find who the real criminal was, because it goes anonymous in the internet. That is one of the problem when it comes to cybercrime. Okay, thank you.
Thank you.
Thank you, Mr. Sony Johuda. Has been told that historical of GDPR. And now we are moved to, it looks like we have covered all the bases. Is there anything else you want me to mention before wrapping up? Okay. Basically, in existing regulation relating to personal data in Indonesia doesn't give sufficient protection, especially with regard to the use of the artificial intelligence. There is any inadequate to encourage digital economic development. Prior to the PDP law, consent was the only legal basis for personal data processing, whilst the approach might be intended to the ultimate from the protection by giving data subject control over the personal data. There is some interest, but basically there should be an independent commission that is independent of government on private interest. Moreover, the model in PDP bill in Indonesia is a comprehensive model governing both the government and private sector. But in Malaysia, model for the governing from the governing sector. So there's a concluded from our the first and the last speaker. So thank you for attending. We hope you have all learned and enjoyed this presentation. Don't forget to fill the attendance list that has been shared in our chat room. Before the end our session, we would like to take pictures again. Please, all distinguished guests, all distinguished speakers, and all participants to activate camera in order to take picture together with our speaker before we hand over to the host. Okay, to all the participants, please open your camera. activate camera to take a picture. Okay. Okay, we start from the slide 1. 1, 2, 3, smile. Okay. The second slide. 1, 2, 3. Okay. The last. 1, 2, 3. Okay. If you want to visit Mr. Sony Julhuda personal blog, you can see the chat for some cyber law and data protection notes. Maybe some question, yeah. We have not fulfill this Zoom. We can see the email, Sir Sony Julhuda. Okay. Okay, thank you. For any inquiries, please send the email Sony IIUMEDU And for Mr. Jelly, if any other question have not completed in our Zoom, we have your email, Mr. Jelly. Okay, thank you, sir. So we have to move the host. Thank you for participating today. Have a great lesson, and you enjoy the presentation. We hope we see another agenda. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you.
Okay, now we're going to call our Secretary Magister Program Study of Law, Universitas Sumatera Utara, Dr. Mahmud Mulyadi SHM. Please, sir, to give our speaker and appreciate it for being able to attend this webinar as a speaker. We'll give to Susoni.
Assalamualaikum warahmatullahi wabarakatuh. To Mr. Sony and Mr. Jelly Lepiza, two smart and handsome speakers until this afternoon. I represent the Dean of the Faculty of Law, Dr. Mahmud Siregar and Prof. Dr. Oka Saidin, Chair of the Master of Law, to say thank you so much for your time, and Mr. Sony and Mr. Jelly, we gained a lot of knowledge in this webinar, and next time, God willing, inshallah, would you please we will collaborate again in activities like this. So once again, say thank you and God bless. And to all participation, all audience in this webinar, we say thanks so much, and we give applause to Mr. Sony and Mr. Jelly Lepiza, the smart and handsome speaker today.
Okay, next we'll give our speaker to Dr. Jelly Lepiza Saimpung. Please, Sir Mahmud.
Yeah, I think Mr. Jelly can come here because be in same room with Mr. Jelly. so I will give you some certificate. Yeah, some certificate. We sorry, Mr. Sony. Mr. Jelly is my colleague, my best friend, and maybe one of ahli experts
No, no, no.
with data. And
Pak Mahmud,
Mr. Sony,
I wish I could
yes?
be there too.
Oh yeah, and please welcome to come to Medan, and we can.
We are waiting for you, Prof. Sony.
Waiting for you to eat durian.
We'll
Durian.
take you eating durian.
Is it
Durian
durian
ucok. Durian ucok. Yeah. Thank you so much, Mr. Jelly Lepiza.
Thank you so much.
Yeah.
Inshallah, thank you.
Nah.
I will
Thank
be
you so much,
happy.
Mr.
I will be
Sony.
happy to visit, inshallah, one day.
Inshallah, inshallah.
Okay, that's really unexpected moment from us to the participants. So here is finally, this is the last session for this international webinar. As a Magister Program Study of Law, Faculty of Law, Universitas Sumatera Utara, really appreciate from all of participants who has been active to question and answer session. Your attendance for this event really as appreciated. But before you're leaving this room meeting, please kindly to fill in the form to make sure your evidence to get your certificate that we have sent at the chat box. So thank you. Wassalamualaikum warahmatullahi wabarakatuh. Thank you, Pak Sony.
Terima kasih, Bu Leslie.
Thank you so much.
Thank you, Pak Sony.
Terima kasih sama-sama. Sama-sama Ibu semua, terima kasih. Saya pamit ya, mudah-mudahan ketemu offline.
Amin. Thank you sekali lagi Pak Sony.
Malaysia.
Terima kasih banyak.
Terima kasih ya Pak.
Terima kasih semuanya. Terima kasih.
Sama. Pamitan. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.